Okay, thank you. Good morning, everyone. This hearing is in the matter of case number CFI 79/2020, consolidated with CFI 43/2021, and is being held by way of video conference before Justice Rene Lemiere. The claimant is represented by El Tamimi and Company. Lead counsel is Ms. Zawiya O'Sullivan, KC. The defendants are represented by Baker Tilly Law Corporation. Lead counsel is Mr. Shaheen Pulikal. Thank you.
Yes, thank you. Now, I can't actually see Ms. O'Sullivan at the moment. Do you have your camera on, Ms. O'Sullivan?
Yes, I do, Your Honour. I can see myself.
That's better. That's better. Thank you. Thank you.
Can you see me now?
I can.
Great.
Can I ask you at the outset, how long do you think you will be in your submissions?
I think I may be as long as 2 hours.
All right.
Because I have a lot to cover.
Yes. What we might do then is that when you've finished your submissions, we'll take a break in the order of 20 minutes. Now, I'm sorry, could you tell me your name? Is it Mr. Shahini?
Yes, Your Lordship, I'm Shaheen.
Right. All right. Thank you. All right. Well, Ms. Sullivan, would you like to start, please?
Yes. Good evening, Your Honour, as I suspect it is where you are.
Well, early afternoon.
Early afternoon. Good afternoon. Your Honour, you're being asked to determine 2 applications by the bank for immediate judgment, as well as a number of counter applications by the defendants. Both applications for immediate judgment are brought by the bank, and Mr., sometimes Dr. B.R. Shetty, is a defendant to both applications. His son, Bine Shetty, is a defendant in the UAE exchange application. And in each case, the bank is claiming under personal guarantees of loans advanced to companies and at that time founded by and at that time controlled by Mr. B.R. Shetty. The first application relates to a loan to NMC Healthcare LLC, where the sum outstanding is approximately $37 million US, inclusive of interest. The second application relates to a loan to UAE Exchange, where the sum outstanding is approximately $44 million US, inclusive of interest. There are up-to-date interest calculations, which I will take you to at the end of my submissions. As to the applicable principles of law, I've set those out in my skeleton at page 1510, and I'm not going to repeat them unless you want me to. We say, Your Honour, there was never a clearer case than this for immediate judgment. The factual defences are, and I choose my words carefully, a pack of lies, and the legal defences are beyond hopeless. Mr. Shetty is clearly seeking to defer the inevitable as long as he can, but is really doing no more than go through the motions. In this, he's being assisted by his lawyer, Mr. Shaheen, and his so-called expert, Mr. Al-Bar, who between them have concocted a risible story of fakery without any awareness that in doing so, they are breaching their duties to the court. I'd like to begin with the NMC Healthcare application. And by the way, Your Honour, am I right in assuming that you've had the opportunity to read the skeletons?
Yes, I have.
Thank you. So I'd like to begin by showing you some of the documents. So if we go to page 46 of the bundle,
Yes.
if you bear with me, it's taking a little time.
Yes, I'm afraid we're all going to have that problem.
Yes. Page 46, this is an extract from Dr. Shetty's defence, where it says that he was the executive vice chairman and CEO of NMC Health PLC until March 2017, and that thereafter he stepped down from that executive capacity. So beginning with the story of this loan, if you could go to page, I'm going to take you to the exhibit of the bank's witness, Mr. Srinivasan, which begins at page 74. And if you go to page 122 of that exhibit, the story begins in June 2015, when NMC Healthcare approaches the bank with a request for credit facilities. And at that point,
Yes.
it's looking for...
I have that.
Yeah. They asked for a 3-year overdraft facility in the sum of $60 million US. As it happens, that proposal does not proceed at that stage, and the next documents date from February 2017. We go to page 123.
Yes.
The next page. We can see from that there was a meeting on the 23rd of February 2017. Discuss the working capital proposal. Then I think if you could perhaps scroll down to page 126. No, you can't scroll, I'm afraid. So you'll need to type in 126.
It adds a bit of time, I'm afraid.
Yes, I'm really sorry about this, but I think it's important to show you the documents.
Yes.
There's no way around it, I'm afraid. It's just very, very slow.
No.
Oh, here we are.
You're in front of me, I'm afraid.
Oh, I'm sorry. It should be, in due course, the excitement of an email of the 21st of February, 2017.
I think you might have to tell me what's in this one, Mr. Sullivan. I'm still seeing the spinning wheel.
Okay, well, right, I'm going to try and cut this down as much as I can, but it is difficult.
Right.
So essentially, on the 21st of February, after a meeting with the bank, NMC Healthcare forwarded soft copies of various documents in support of its application, including an information memorandum. For your lordship's reference, without going there, the information memorandum begins at page 128. And on page 140, there is a profile of Mr. Shetty, which mentions that he is the managing director and CEO of UEA Exchange, which is the other company involved in this matter.
Yeah.
At this time, Dr. Shetty was a very high-profile businessman in the UAE. Now, if I could ask Your Honour to go to page 149. Your Honour, I'm wondering whether there's going to be a practical way around this.
I do have that at the moment.
You have that. I don't have it yet. I mean, I wonder whether if the other side is prepared to agree, my instructing solicitors could send you a PDF of the bundle to download, which would make life much quicker. Otherwise, I'm afraid we're going to have this. It's going to double the length of the hearing.
You could try.
I'll carry on for the moment, but if my instructing solicitors are on this call, and I would ask if they could kindly send to the court and the parties a PDF copy of the bundle.
I could.
So, Your Honour, the thing is, I think it's very important in the light of the ludicrous allegations of forgery that have been made to take you through the very careful process that the bank went through to obtain signatures. This is why I'm taking you to the document. So I'm going to have to ask you to indulge me. So on page 149, which you have in front of you, the bank approves the facility on the 22nd of June 2017.
Yes.
And if one goes down to page 151, you can see that one of the stipulations is for a personal guarantee from Mr. Shetty, who's said to have net worth of $1.93 billion US.
Yes.
Anyway, well, I shall carry on for the moment. And then
Yes.
again, for your lordship's note, at page 165, there is an email which tells us that Mr. Shetty is the signatory authorized to execute the term sheet. At this stage, it's only at term sheet point, and copies of his passport and visa status are provided. Then on page 175, oh dear, yes, there we are. So there's the page 151 has just come up on my screen, my lord. Do you have that?
I did, yes.
You did.
It's about
Well, never mind. It referred to corporate guarantees from a number of the NMC health companies, including the borrower itself, and a personal guarantee of Dr. B.R. Shetty, described as promoter. And then on 175, and we will need to go to this.
175?
175, yes. So here, Mr. Kumar from from the bank is saying, we confirm that Dr. B.R. Shetty is the sole signatory for NMC Healthcare LLC, that's the borrower, and he's been authorized through the POA executed by all three shareholders. And then again, for your lordship's note, on page 181, you needn't go there, there's a notarized copy of the board of the holding company of NMC Healthcare, resolving that NMC Healthcare should grant Dr. Shetty a power of attorney. And that's the power of attorney that's referred to in this email. And then I think it would be worth looking at page 184. This is an internal document within the bank, again recording that B.R. Shetty is to provide a personal guarantee, a security of the advance to NMC Healthcare. And the reason why I wanted to take you to these documents, there are more, but is to show that the careful and formal process which the bank went through when providing the loan and the importance to it of obtaining a personal guarantee from Dr. Shetty. Can we move to page 83, because that's where we find the facility agreement. Oh, there it is.
Page 83.
83, yes, we're moving on to the document I was trying to show you. I mean, I'm sorry, this is really actually getting in the way of providing a fair hearing, I'm afraid, the slowness of this loading. It may, I don't know whether it's worth adjourning for 10 minutes or so, Your Honour, to see if there's some solution.
Perhaps you have in mind, I could try downloading perhaps the case bundle itself. I'm not sure if it'll work any quicker there. Perhaps we might try that. If we try,
if you're able to try that, I think that would help.
All right, it's 15 minutes past the hour now.
Yes.
So perhaps if we adjourn to 25 minutes past the hour and see how we're all placed then.
Thank you very much. Thank you very much.
All right. Was that yes?
I'm able to hear, yes.
Yes, all right. Well, thank you, Mr. Sullivan. I think we're ready to carry on.
Thank you so much. May I just check that Mr. Shaheen has a workable copy of the bundle?
there is a delay, there is a lag, I believe. I've said 3 times now.
All right.
Thank you. Right, thank you. Then I shall continue.
Yes,
Your Honour,
please.
I wanted to show you briefly page 184 of the bundle, which is the bank's internal document recording
Yes.
the agreement to provide the facility and the security which is to be provided. Next, and you can see that the drafting of the documents has been entrusted to Al-Tamimi, and the following formal documents have been finalised for execution, including the personal guarantee.
Yes.
So if we now go to the facility agreement itself, which is on page 83, dated the 7th of August,
Yes.
and as you can see, it's for 50 million. If you go to page 90, you'll find the definition of personal guarantor.
Yes.
If you go to page 93, you will find under clause 2.1 the agreement of the lender to make available the facility in an aggregate amount equal to the total commitments for working capital purposes. And if you could scroll down to the next page and to clause 2.7, that gives the bank an unfettered right to demand repayment at any time of the outstanding amounts.
Yes.
If you go to page 96, clause 7 deals with interest. I mean, there is the daily interest, but at 7.3 there is also default interest once there's an event of default. And then if we go down to page 111, you will see the events of default clause. There are a number of events of default. The bank principally relies upon clause 20.1, which is the failure to pay on the due date any amount payable pursuant to a finance document at the place and in the currency in which it's expressed to be payable.
Yes.
Now, if we go to page 118, Schedule 1 contains conditions precedent to initial utilisation, and paragraph 3 sets out the executed documents. The originals must be received, duly executed of, amongst other things, the guarantees. So no money is going to be released under this facility until duly executed originals have been received.
Yes.
And if we go to page 121, we'll see the signature page. Executed. Now, while there's dispute as to the authenticity of this signature, there's no dispute that it says B.R. Shetty. And that is signed on behalf of the borrower. You'll note that Mr. Srinivasan has executed it on behalf of the bank, and we'll come to his evidence in a moment.
Right.
So now if we could go to the PG, as I'll call it, the personal guarantee, page 76. And I invite you to look at recitals A and B, because they will be important when we come to the construction of the guarantee in a little while. So firstly, it's clear that the bank has agreed to extend an overdraft facility for an amount up to $50 million, and has referenced the terms of the facility, and then it's made clear that it's a condition precedent to the obligations of the bank that the guarantor guarantees the performance by the borrower.
Yes.
Now, if you could go to page 78, this is headed waiver. This is standard wording, Your Honour, which is designed to prevent the application of the principle in Holman Brunskill, which we'll come to later. As Your Honour knows, the principle from that 19th century case is that a material variation of the underlying debt made without the consent of the guarantor will discharge the guarantee. And so it's absolutely boilerplate for banks to include wording of this sort in their guarantees. If you could scroll down to the next page, to clause 6b, because it says there that Mr. Shetty waives the rights, remedies, defences, or exceptions that may be available to him under UAE law. If we scroll down to clause 7.2, This is also important because it makes clear that the bank may sue on the guarantee without first taking any action against the borrower or any other surety.
Yes.
And if you go down to clause 10, there's a principal obligor clause, which makes clear that this is not only a guarantee, but also an indemnity imposing primary liability on Mr. Shetty, which means that the bank doesn't have to prove that the debtor is in fact indebted to it, only that it's made demand for a sum which has not been paid. If you go down to page 81, clause 18 addresses governing law and jurisdiction. You will see that there's an express choice of the laws of the UAE and a submission to the non-exclusive jurisdiction of the courts of Dubai, UAE, and there's no dispute that the DIFC court is one of the courts of Dubai, UAE. And if you go down to the next page, page 82, you will see that this is the signature page. Now I'd like to take you to Mr. Srinivasan's evidence about the signature of the facility agreement and the personal guarantee. He was at that time the deputy CEO of the bank's Dubai branch. And if you could go to page 69, you will see paragraph 24 and following of his witness statement. He explains here that Mr. Shetty was such an important customer of the bank that both the deputy CEO and the CEO travelled to Abu Dhabi for the formal signing of the documents. Has Your Honour had a chance to read this statement?
I have, yes.
Thank you very much. So I'd just like to take you to page 188, which is an extract from the movement register of the company. And the relevant page, yes, it should be 188 on you see entry number 30, 7817. Deputy CEO and CEO, NMC Healthcare. It shows that they left at 14:20 and returned at about 1900. So they were driven there by the bank's driver.
Yes.
If you could return to page 70. And
Yes.
I mean, you can see from paragraph 29 that Mr. Srinivasan has a very clear recollection of seeing Dr. Shetty sign 4 documents: the facility agreement, the personal guarantee, the confirmation letter.
Or seeing somebody who said he was Mr. Shetty sign the documents.
Yes, you could say that. Or I think there's, yes, you could say that. On the other hand, a copy of Mr. Shetty's passport has been provided to the bank, and he's clearly the man in the passport.
Yes. And it's no doubt Mr. Shetty doesn't dispute he's in the photograph. He disputes when the photograph was taken.
Yes, the photograph actually relates to the.
Oh yes, that's the earlier one. Sorry.
Yes, the other one. But what this one has, there is. I mean, for the sake of completeness, we do have at 193 a copy of the card which Mr. Srinivasan states that he retained at the time, but obviously that doesn't particularly add much to the picture.
Yes.
But the point is that none of this is contradicted by Mr. Shetty. He's not put in a witness statement to say, I never travelled. There was no meeting in Abu Dhabi. I never attended the meeting in Abu Dhabi. He just says he can't remember. And he can't exclude the possibility that someone forged his signature. He certainly has never said someone impersonated him.
No.
Anyway. So, following the signature, the full amount of facilities. Sorry.
Is my recollection correct, Mr. Sullivan? In relation to these documents, Mr. Shetty, in his defence and his solicitor repeating it in his witness statement, says that he has no recollection.
That's right. In both cases.
Whereas in the UAE one, UAE exchange, he actually denies it.
Well,
in
it's
his
like,
particulars.
yes, it's true that the defence in the UAE exchange is asserted more strongly. I think actually in both, he claims not to recollect signing the documents.
Yes.
We can look at the defence. But
Yeah.
yes, here he simply says, I can't exclude the possibility that someone has forged my signature, whereas he
Yes.
actually comes out and says it in the other case.
Yeah.
And then just to show you that following this meeting, the full amount of the facility was drawn down in two tranches of $25 million US each on the 14th of August. So for the reference, that's 195 and 196.
Yes.
Obviously, the bank would not have done that. Again, that appears to be the signature of Mr. Shetty, but there it is. But obviously, the bank wouldn't have done that if it not considered that it received duly signed copies of the originals. So, and then the amount of the facility fluctuates up and down over time because it's a working capital loan. Now, fast forward to April 2020. As Your Honour probably knows, in April 2020, the English parent company of the NMC Health Group went into administration in England after the discovery of a massive fraud at the group. I should say that Mr. Shetty disclaims any responsibility for the fraud. It's no part of the bank's case that he was responsible for it. The insolvency of the English parent was rapidly followed by the insolvency of the many UAE companies, including the borrower in this case, NMC Healthcare LLC. And as Your Honour probably knows, they are all currently in administration in the ADGM.
Yes.
Now, the insolvency of the borrower prompted the bank to demand the immediate repayment of the facility, which it did on the 22nd of April 2020. We don't have that letter of demand, but it's referred to by Mr. Srinivasan at page 34 of his statement on page 71.
Yes.
So on the 28th of May 2020, the bank served a demand under the guarantee on Dr. Shetty, and that is at page 200.
Yes.
Now, Dr. Shetty's never positively denied or actually said anything about whether he received this demand. So I'd like to show you how this is pleaded. If you look to the particulars of claim on page 33, paragraph 26. It says, despite numerous requests for payment, i.e. by notice dated 16th of April 2020 and notice dated 28th of May 2020 addressed to the sixth defendant, Mr. B.R. Shetty, and 22nd of September 2020 to the defendants. So that's what's pleaded. But if you now go to page 50, which is how the defence responds to it, he says, well, the allegation is woefully underparticularised and he's unable to respond. But it wasn't unparticularised, it was precisely particularised. So this defence is evasive. Now, on the 22nd of September, the bank sent Mr. Shetty what's called a recall and invocation demand notice, declaring the sums due and invoking the guarantees, which is at page 205.
Yes.
And on page 206, you see the reference to earlier notices, notifying the outstanding amount as of 15th September, identifying various events of default which are said to have occurred, and so on. And so they reserve the right to commence legal proceedings. And in fact, these proceedings are then commenced a few days later. And as we've seen, this is a document to which Mr. Shetty has refused to plead, even though it is particularised. So let's look then at the defence at page 43. In this case, Mr. Shetty, Dr. Shetty, is the 6th defendant. And there's a summary, paragraph 2 on page 44.
Yes.
So curiously, he refutes that he personally guaranteed the facility, but he says he doesn't recollect to agreeing in executing the credit facility or the corporate guarantees or a personal guarantee. And he puts the bank to proof. And there we get to 3.1, the tepid suggestion that he cannot exclude the possibility that documents which purportedly contain his signature were forged without his authority by one or more of the NMC defendants' management. We've never had any particulars of who that person might have been. And we submit that, frankly, the suggestion that he could have forgotten the advance of a 50 million facility for working capital of his company is entirely implausible. And in my skeleton, I drew your honour's attention to the Court of Appeal's decision in the Al Mazrui case, where Chief Justice Zaki Azmi said, if a defendant's going to allege his signature was forged, it needs to produce at least some evidence to show the court there's some basis for the allegation. He has to do more than just put the other party to proof. And one would normally expect the defendant to produce a handwriting expert report. In this case, there is a so-called expert report prepared by Mr. Albar after inspecting the originals of the 4 documents held by the bank. An application for permission to rely upon this report was not made until the 13th of November, although the report itself is dated the 19th of September and was referred to by Mr. Shaheen in his second witness statement of the 25th of September. There's been no explanation of this delay, but we are content for you to look at it, de bene esse. It's at page 1564. And I don't know if your lordship's had the opportunity to look at this.
I have, yes.
Yeah, thank you. So if one goes to 1565, one can see that Mr. Albar inspected 2 documents, the facility agreement, the personal guarantee, 2 other documents signed by Mr. Shetty, and to see whether he wrote them. Now, he didn't compare them with any uncontested signatures of B.R. Shetty, so he was never going to be able to say whether or not they were authentic. I mean, that's the most basic requirement for a handwriting expert. And we can see that, for example, if one looks at paragraph 9, yeah, he says, no other documents that bear Dr. Shetty's signature were provided for inspection as confirmed by Altamini, but it's not the responsibility of the bank to provide other documents with his genuine signature, his uncontested signature. It's for his client. I mean, extraordinary. So he can't and does not say that the signatures are not the signatures of Mr. Shetty. What he says instead is that 2 of the documents contain pre-used signatures of Mr. Shetty. That is the letter of confirmation and the letter of undertaking. Those are not the documents upon which the bank found its case.
Mr. Shahini may tell me why, but on my reading of it, the expert raises matters of suspicion, but nothing which would found an opinion that he eventually expresses.
I was personally present.
Well, not now, Mr. Shahini. You'll have your chance later on.
Yes.
I was just in effect giving Mr. O'Sullivan an opportunity to tell me whether she agrees with that.
What about you? But your lordship, your honour has anticipated my submission. I mean, look at it, page 1567, where there's a summary table. The original facility agreement. I mean, the most you can do is say signatures are provided on a separate page, which could have been attached. And as I've said in my skeleton, and that really suggests that the signature is in fact genuine, but has been taken from some other document and attached. And this is all speculation. None of this is pleaded, and it's wholly improper for Mr. Albar to raise speculations of this sort. I make the same point about section 2. Again, he speculates that because there's a separate signature page, that it could have been a document could have been attached from some other document. What We have no idea. And then here, in 3 and 4, I mean, these aren't letter documents on which we rely for the claim, but again, he purports to make a finding that both letters were pre-signed by Dr. Shetty on blank papers and were misused. I don't know where he got that from, because there's no instructions from that by Dr. Shetty, not a single piece of supporting evidence. And then we carry on to paragraph 12, 1568, and now we veer into completely different territory. As I've said, it purports to give evidence about what banks ought to do when executing security documents. Well, that's not his expertise, and he's got no basis stepping into this area. So, I mean, your Honour's read this, and in our submission, this, I mean, he goes on to accuse the bank of negligence, but I mean, it's nothing to do with him. This obviously fails to provide any credible support for the suggestion that Mr. Shetty's signature on the guarantee and the facility agreement were forged, or that it was a genuine signature which was somehow attached by the bank to these documents. And this must be an allegation against the bank, because the bank is in possession of the originals. Now look at what Mr. Shaheen says in his skeleton argument. If you go to page 1529. Paragraph 15. In paragraph 16, in fact. He says, the inspection by Mr. Albar revealed substantially alarming discrepancies with respect to the authenticity of Mr. B.R. Shetty's signature in the disputed PG and the disputed facility agreement. Well, it does not. That is a total misleading description of what this expert report finds. Where he then, to be fair, then goes on to summarise what Mr. Albar finds. Of course, that's nothing to do with authenticity. Now, if you go down to paragraph 18, there's a reference to the claimant's expert. Well, that's puzzling, because we don't have an expert. We don't need to rely on handwriting evidence, given the evidence of Mr. Srinivasan, that he personally watched Mr. Shetty sign all 4 documents. That evidence has not been contradicted by any evidence on the part of Mr. Shetty. Here is the evidence to jog his memory. So we invite you to reject the forgery defence as fanciful and dishonest. And we also invite you to find that Mr. Shaheen and Mr. Albar have concocted an absurd theory about the reuse of documents bearing genuine signatures, which flies in the face of the bank's obviously credible evidence. These allegations are utterly improper, and in Mr. Shaheen's case, a breach of the DIFC Court's Code of Conduct for Practitioners, which include a requirement at paragraph 23, paragraph N, that a practitioner shall not contrive facts which will assist his client's case, or draft any originating process, pleading, affidavit, witness statement, or notice or grounds of appeal containing A, any statement of fact or contention, as the case may be, which is not supported by his client's instructions or by other reasonably credible material, B, any allegation of fraud or criminal behaviour, unless he has clear instructions to make such allegation and has before him reasonably credible material, which as it stands establishes a prima facie case of fraud or criminal behaviour. There is not the faintest support for the allegation that the signature of Dr. Shetty has been forged. And the alternative suggestion that there's somehow a genuine signature which has been signed in blank and reused contradicts the forgery case, has not been pleaded, and is not supported by evidence from Dr. Shetty or anyone else. So that's the chief defence of fact. But I would like to deal with various legal defences which have been advanced by Mr. Shaheen. They haven't on the whole been pleaded, but have been the subject of submission by Mr. Shaheen in his various witness statements and his skeleton argument. The first of those, if we can go to page 1537, paragraph 50, where this is in respect of both applications. Mr. Shaheen says the liability of the borrower has not been ascertained and the guarantor is not liable to pay until the liability is ascertained. Now, if you go to the particulars of claim at page 26. You'll see that there is pleaded the amount due as at the 15th September 2020.
So which paragraph is that?
You'll have to scroll down. It's
Oh,
sorry. Yes, can you see it?
Yes,
Yes.
I can.
It's paragraph 18, yes.
Yeah.
So I won't scroll down, but at page 41, this has been signed with a statement of truth, and it can be relied upon as evidence. And then the rest is simply the calculation of interest. And if you want to see that, it's page 1915.
1915.
1915, yes. And if you scroll down to the bottom of that, you'll see the outstanding amount. The person preparing this has included the legal charges, so it's actually slightly less than 37. I'll give you the precise figure at the end of my submissions.
All right.
But you can see it includes the outstanding amount, then there's penal interest, and then CI, which is contractual interest.
Yes.
So this is an ascertainment on unchallenged evidence of the amount due from the borrower. And as I pointed out, this is not simply a guarantee, but the PG is not simply a guarantee, but also an indemnity. The bank doesn't have to prove that the borrower actually owes any particular sum, but that it has demanded payment and that the borrower has not paid the sum demanded. Those matters are in evidence. Now, if we go back to Mr. Shaheen's skeleton at 1538. Martin, you look here at paragraph 55.
Yes.
And what he seems to say here is that under Article 391 of the Commercial Transactions Law, the accounts must be closed, and the amount remaining in the accounts after closure will be considered as the amount that needs to be paid. I mean, that submission is quite difficult to understand, but I think what he's saying there is until the accounts are closed, there's no debt which can be claimed, and he says there's no evidence the accounts have been closed. I mean, that in my submission is a ridiculous submission which fails to understand what the Commercial Transaction Law actually provides. And that is set out at page 1649. So what Mr. Sheen was referring to, I think, Article 390, and it says a current account is a contract between two persons under which the rights and debts arising from their mutual relationship are converted into entries to be made into the account, for which clearance shall be conducted, so that the final balance upon the closure of the account shall alone constitute a payable debt. Now, that doesn't say you can't claim for a debt unless the account is closed first. What it says, in effect, is that you have to set off the parties' mutual dealings so that only the final balance, after taking into account all those dealings, is the sum payable as a debt. And this effect was closed when the debt was, this account was closed when the debt was classified as a non-performing asset. If you go to page 199, there's a statement of account I was going to show you earlier. It actually begins at page 197, and it's a complete statement account for this loan. And you can see that it's GL subhead, I think that's General Ledger subhead 76115. And that records the various entries in and out. And if you go down to the end of that document, which is on page 199, you will see that on the 1st of June 2020, the outstanding balance was transferred to a different account after it was classified as a non-performing asset. So it's transferred from G3101 to 76115. So that's the end of Mr. Shaheen's point in my submission. Now, his next point is based on Article 1061 of the UAE Civil Code. So if we could, I invite Your Honour to go back to page 1539. And this is now paragraph 60 and following.
Yes.
And Your Honour, he quotes from Article 1061. The validity of a suretyship is conditioned on its object being warranted by the principal as a known debt, kind or person, and being deliverable by the surety. Now he says, well, this amount is not for a fixed amount, and therefore it's void. Now, the short answer to this, if I could refer you to page 79, lies in clause 6b of the guarantee, under which Dr. Shetty waives any rights and remedies under UA law.
So which clauses? 6b?
6b, yes, on page 79.
Yeah. Yes.
But even if Article 1061 did apply, its requirements are met. And as I've explained in my skeleton, and I simply refer you here to paragraphs 33 and following at page 1516. So it's from paragraph 33 on, I've dealt with this. And I say in effect that as a matter of UAE law, a guarantee is valid if it either sets out the precise amount of the guaranteed debt, or the amount can be ascertained from the terms of the facility, which you can in this case. Now, he has referred to the decision of Justice Lord Glennie in Velocity Industries, where he was considering a personal guarantee. But as you can see from the extracts set out at paragraph 34 of my skeleton, the guarantee in that case was extremely widely drafted, and the underlining is that of Justice Lord Glennie. So you see it covered any present or future liability, including contingent liabilities, and it was not just limited to a particular facility agreement, but expressed to be made in relation to any further advance under any agreement, supplemental to any document.
Yes.
So I think at this point, it makes sense to look at what Lord Glennie says, which is at page 1494.
Yes.
Now, this section, I mean, this is a long judgment that deals with many issues, but this section begins at 119, towards the bottom of the page. And he there sets out an article, comment of 120 from an article published by LexisNexis, which notes that an all monies guarantee may not be enforceable in the UAE. And it specifies that Article 1061 requires the issuance of guarantees subject to specified debt or thing that is certain in amount, and must therefore refer to the amount or facility guaranteed by the guarantor. Further, the Dubai Court of Cassation has held that the guarantee contract shall be void unless it determines the guaranteed amount or includes the basis on which the amount guaranteed should be calculated, or refers to the credit facility granted to the principal debtor. I'll come to those Dubai Court of Cassation cases shortly. But essentially, Lord Glennie says the passages appear to confirm the interpretation placed upon it by the defendants. There it is. They have to be an amount either for a fixed amount or amount capable of being ascertained from the terms of facility and cannot extend beyond the four corners of the facility being guaranteed. And then he sets out at the next paragraph the extract, which I referred you to a moment ago, of the wording of the PG, which is extremely wide.
Yes.
Definition of liabilities. And so at 122, he reaches the conclusion that the PGs cannot extend beyond the four corners of the MFA. That seems to me correct, and I am satisfied that the terms of the PGs do go further. They purport to cover not only future and contingent liabilities, but also liabilities arising under any agreement, not just the MFA. And then he asks the next question, which is, what happens if they, by their terms, do extend beyond the four corners of the MFA? And he goes on to reach the conclusion at the end of the paragraph that the PG is void if it extends beyond the four corners of the MFA. So in that case, he held that the guarantee was void for non-compliance with Article 1061. But our case is quite different. And of course, any of these cases have to turn on the wording of the guarantee. So if one looks at page 76, which is the PG in our case, I asked you to look at the recitals earlier.
Yes.
So you can see there that under the recitals, there's a very clear identification of the maximum amount of the facility which is being guaranteed. And then if one scrolls down to 1.1, one can see that the guarantor is irrevocably and unconditionally guarantees and promises to pay on demand any and all sums of money that the borrowers are obligated to pay to the bank under the facility agreement, that the borrowers shall have failed, omitted to pay when due in accordance with the terms of the facility agreement. This is obviously subject to my point about it also being an indemnity. But in essence, what's guaranteed here is that the guarantor is guaranteeing sums actually due from the borrowers under an identified facility agreement with an identified limit. It doesn't extend to future and contingent liabilities. It doesn't extend to other loan agreements. So it is distinguishable from the Velocity Industries case. And in terms, I think as far as the cassation court cases are concerned, I think the easiest thing will be for me to refer you back to my skeleton at page 1518. The cases are
a separate copy of it. What paragraph in your skeleton?
It's paragraph 38.
Yes.
The cases are all in the bundle, and I've verified the footnotes, they're accurate, so you can track them down, but I've set out for convenience the relevant points. I mean, your Honour's read the skeleton, but essentially, I mean, it's quite clear that these cases support the construction placed by the article quoted by Lord Glennie and also his own conclusion, essentially. So it's not necessary to have a fixed amount, provided that there's reference to the facility agreement and the amount is capable of being ascertained in accordance with the terms of the facility agreement. And in fact, I've underlined in particular in paragraph 40 the words, further, a guarantee is valid even if it does not contain or identify a value for the guaranteed debt, as long as the basis for calculating the guaranteed debt in the future is contained within it. And similarly, 41, I've again underlined the key passages.
Yes.
So we say that even if 1061 applied, which it doesn't because the right to rely upon it has been waived, it will be no answer because this clearly guarantee is within the four corners of the facility agreement. So moving on to one of the points made by Mr. Shetty in his application for a stay, he's essentially saying these proceedings ought to be stayed until the conclusion of the administration of the NMC Healthcare Group in the ADGM, which is expected to take years. Now, as I pointed out, clause 7.2 of the PG is the definitive answer to this question. One looks at page 79. Again, this wording is entirely standard for a commercial guarantee.
Yes.
And the correct analysis is that the bank is entitled to enforce in full against Dr. Shetty, and then to the extent that he pays, he himself is entitled to prove in the administration of NMC Healthcare LLC, provided he has paid those sums. And that's the whole function of a guarantee, is that it should be available in the event of the insolvency of the principal debtor. So those are the points raised, as far as I'm aware, in relation to the NMC Healthcare application. So I'd like to move on to the UAE exchange claim, which I think I can take more quickly. We can go to the facility agreement, which is 572. This was initially for a $10 million short-term facility agreement. And I'd just like to draw your attention to the signature page at 593. And in fact, on this occasion, each page of the facility agreement was initialed by Dr. Shetty. Now, if you go on to 599, oh, sorry, I should explain that, sorry, 601 first. shows that there was a personal guarantee from Dr. Shetty, or Mr. Shetty. And again, if one goes to clause 10.1 of this, on page 607, you'll see that in this case, the guarantee was not governed by UAE law, but specifically by DIFC law.
Okay, which clause is that?
10.1 on page 607. And you can see that this was signed by Dr. Shetty on this page. And again, he's initialed every page of this personal guarantee.
Yes.
So this was increased to $25 million by a supplemental agreement of the 8th of September, which is page 599. And you can see from the page 2.1 that the amount of the facility is increased to 25 million. And again, Mr. Shetty gave a personal guarantee for the increased amount at page 608. And I invite your Honour to notice that this is in 2010. This is some time ago, where even by his own account, Dr. Shetty was fully in control of the company. But there it is. That's the guarantee. And the signature is at 614. And again, it's, in this case, actually signed by him on every page of the guarantee. And then this was increased again to 50 million by a second supplemental agreement made on the 5th of March 2012, which is at page 660. And again, he gave a personal guarantee at 664. And which he signed on 677. And also on every page. And on this occasion, his son, Mr. Rene Shetty, also gave a personal guarantee for the full amount, which is at page 686. He signed that at page 693. Note the witnesses from UAE Exchange LLC. And again, Mr. Rene Shetty also signed this guarantee on every page.
Yes.
Your Honour has evidence from former senior employees of the bank who witnessed the signing. So Mr. Raj Kumar gives evidence, paragraph 16 of his statement, which is page 569. He makes it clear from paragraph 13 that the guarantee would never have been entered into or increased without the personal guarantees. Now, he says, paragraph 16, he personally witnessed Mr. or Dr. B.R. Shetty signing the first personal guarantee in the initial facility agreement on the 15th of June 2010. And he explains that it was the practice of the claimant to have a member of its senior management attend. And he explains in paragraph 18 that he then travelled from Dubai to the offices of UAE Exchange in Abu Dhabi, taking the documents with him, arriving there in the morning, having been driven there by the claimant's driver, remembers distinctly several other members of the management being present, and there was reference to the photograph. I mean, as your Honour rightly observed, Mr. Shetty says that the photographs were taken on another occasion. But here you have clear evidence from someone for whom this was important enough for him to travel to Abu Dhabi to witness the personal signature by the founder and CEO of UAE Exchange. If you want to look at the photographs, they're at page 619 and 620.
Yes, I have seen them.
Yes. Now, as far as the first supplemental agreement is concerned, there is no witness to the signing of that. But the second supplemental agreement from April 2012 was personally witnessed by Ms. Baskaran of the bank. If you go to paragraph page 793.
Sorry, just tell me, you said the first
supplemental
agreement. What was the date of that?
It was September 2010. I think it was the 8th of, yes, 8th of September 2010.
I had a note that Mr. Bhaskaran said he witnessed it. Do I have that wrong?
Oh, you meant, no, you're probably right. No, it's Miss Bhaskaran. No,
Miss Bhaskaran.
I think not. She signed the second one.
Ah,
If you
okay.
see on it's page 793, paragraph 14. And she, I believe, has taken over as the deputy CEO by this point.
I see.
And she says, I personally signed as witness Mr. Seti sign it, and I also signed it on behalf of the
Yes.
Yes, and she remembers the awards and trophies, and she refers to the other witnesses.
Yes.
Interesting to see the reference to Mr. Al Mazruri, who was the subject of the observations by the Chief Justice in the Mazruri case. Yes, so she's very clear about paragraph 17 about witnessing the signature by Dr. Shetty, and she signed every page of his personal guarantee. And I should emphasize, Mr. B.R. Shetty at this point was a complete celebrity in the UAE. I mean, he was incredibly well known as the founder of these very high value and apparently incredibly successful groups, NMC Health and UAE Exchange. You know, he really was extremely well known and treated extremely deferentially by the bank, as you can see. Now, she also says, Ms. Bhaskaran says that she also witnessed the signature by Mr. Rene Shetty, the son of Dr. Shetty. Now, as we've already noted, in this case, the defendants do advance a positive allegation of forgery, which one can see, for example, at paragraph 551.
So page 551?
Page 551, yes. This is Mr. Shetty's defense.
Right.
Where he positively denies the guarantee, signing any of the facility agreements or the personal guarantees, and he says that the signatures relied upon are forgeries, and he says he's going to rely upon an experienced qualified forensic document examiner. Well, he's had the chance to do that, but he's never put in any report. Similar points are made by Mr. Rene Shetty on page 557. Now, he says correctly that he wasn't a signatory to the original facility agreement or the supplemental agreement, or indeed, I think, the second supplemental agreement. But he, as far as the personal guarantee is concerned, that's dealt with at paragraph 4, denies that he issued a personal guarantee. And he says it's a fraudulent act of forgery. And again, he says at 4.3, he's going to rely upon the opinion of a qualified document examiner. But he hasn't, and he hasn't identified anyone who might possibly have forged his signatures. So, I mean, really, Your Honour, we invite you to find that this defence, in the light of the uncontradicted evidence of the bank's witnesses, in the light of the signature of all these documents over a period of several years, it's not only fanciful, but dishonest. Can't possibly disclose any basis for holding that this matter should go to trial. Dealing with the legal defences raised by Mr. Shaheen in his witness statements, again, it's said that the sum due from UAE Exchange is not ascertained. But again, that's been pleaded by the bank with a statement of truth in its amended claim form, which you'll see at page 541. The amount find the relevant, it's said to be due. Yeah, anyway, it gives the amount due, yes. It's 34,991 as at the 28th of February, 2021. And again, the interest calculation, inclusive of interest to the 17th of November, is at page 1916.
Is that verified by somebody? Where does that table come from?
It has been prepared. It has been prepared by the bank last Friday. It hasn't been verified. It can be verified if there's any dispute as to its accuracy. But it's been given to my learned friend as of Friday, and I'm not aware there's any dispute as to its accuracy.
All right. But
I'll leave Mr. Shaheen to comment on that.
Yes.
Now, and again, another argument raised by Mr. Shaheen in his skeleton is in reliance on what's called Article 121 bis of Federal Law number 14 of 2018. That came into force in about January 2023. It's essentially consumer protection legislation, which holds that unsecured personal guarantees are unenforceable. I shall come to that in a bit more detail, but essentially, he says that these are unenforceable because they are unsecured. But the first point to that is this particular law doesn't apply in the DIFC because of the Article 3.2 of the Federal Law number 8 of 2004 regarding the financial free zones. If you want to look at 1904, if you scroll down to Article 3.2, the zones, that's the free zones, and financial activity shall also be subject to all federal laws with the exception of
which article? Which article?
Article 3.2 of the Financial Free Zones Law. But essentially, there's an exception carved out for federal, civil, and commercial laws.
Yes.
So it's not open to the defendants to rely upon the recent amendments to Federal Law number 14 of 2018. But in any event, that particular article has been held both by the Dubai Court of Cassation and in a recent decision by the English Commercial Court not to apply to guarantees of corporate lending, such as those in the present case. I'd like to draw your attention to a recent decision of the Commercial Court in Invest Bank and El Husseini, which is at page 1883. Now, reliance is placed on that article. The relevant section begins on 1895. Where he talks about the question here is whether the guarantees remain valid and enforceable as a matter of UAE law, which is the law by which they are governed, which is not the same thing as the law of Abu Dhabi.
So which paragraph? Which paragraph?
Paragraph 63.
63, thank you.
Yes. So I'm afraid the article, if you do you want to see the wording of the article? I don't have the reference, but it must be within this judgment earlier.
Well, I'll find it.
Yes, but there it is. So essentially, I mean, he says that there are two issues. One is the applicability of the article to a personal guarantee given as a security for a credit facility provided by a licensed financial institution to a corporate borrower. The second point doesn't arise. And he goes on to say the court's role in this context is a predictive one. That's paragraph 65. And then at 66, he says, on its own plain language, Article 121B is not applicable to either of the guarantees. Each is a personal guarantee provided by D1, a security for borrowings by a limited liability company rather than a private sole enterprise. The guarantees themselves are, of course, not credit facilities. They are a form of personal security for such corporate borrowing. The key point is the type of corporate borrower involved. This was not consumer borrowing. And then I mean, you can read this at your leisure, Your Honour, but if you scroll down to 75, it discusses a recent decision of the, sorry, hang on, of the Dubai, yes, here we are, 69. A recent decision.
69?
Sorry, 69, Your Honour, skipped too
Yes.
far. Paragraph 69, a recent decision of the highest court of Dubai, and I'm not sure we've got this in the bundle because as this judgment shows, it was delivered recently and translated for the purposes of this hearing. It says, recent decision of the highest court in Dubai has found that Article 121B does not provide protection to a limited liability company which borrows money, and so upheld the lower court's decision to allow enforcement against such borrower and its personal guarantor. And he goes on to observe that the Court of Cassation says that circulars to the Judicial Council or another emirate have no legal force in Dubai. And he goes on, yes, he refers to retrospective effect at paragraph 70. Yes, so he then at 75, he says, I cannot find that UAE execution judgments, these are judgments basically where the Abu Dhabi court says you can't execute because Article 1.121B applies. He says the Dubai CC has clearly held that Article 121B has no application in a materially identical contractual matrix, nor therefore can Article 121B provide protection to the personal guarantor of such corporate borrowing. This accords with the plain language of Article 121B itself, as well as the consumer protection rationale and characterization of such provision. And then 77, I conclude therefore that the proper meaning of Article 121B as a matter of UAE law is that it does not cover corporate borrowing or therefore personal guarantees in respect of such corporate borrowing, and concludes at 78 that they are valid and enforceable as a matter of UAE law. So that really knocks that argument on the head. Now, in terms of other legal arguments put forward by Mr. Shaheen, again, he tries to rely on Article 161 of the UAE Civil Code. But as I've just pointed out, the guarantee is governed by DIFC law, and by virtue of Article 3.2 of the Financial Free Zones law, the civil and commercial laws of the UAE do not apply in the DIFC. So Article 161 has no application. Now, there's another point raised by Mr. Shaheen at page 1532. And this is paragraph 28 onwards. And he says, over and above the defence of forgery, it is pertinent to note there is evidence set out in the reply to prove that the claimant did not adequately evaluate the credit risk posed by UAE Exchange or did not adhere to the guidance outlined in the DIFC prudential rules. So, I mean, that's a very unattractive argument, given that UAE Exchange benefited from a $50 million facility, but is irrelevant even if true. Even if these matters are true, they would not afford the guarantors any defence. It's no defence for a guarantor to argue that the creditor has failed to take reasonable care to look after its own interests, and the DIFC prudential rules are not intended to confer a cause of action on guarantors. Now, Dr. Shetty already ran this argument, exactly the same argument, unsuccessfully in an earlier claim by Barclays Bank, where I appeared for the bank, and where it was rejected by Justice Wayne Martin. That judgment is at page 1422. So the pertinent section is at paragraph 130 at 1452.
At what page?
1452. So as you will see there, in effect, that Justice Martin there summarizes allegations to the effect that Barclays was negligent or in breach of a regulatory obligation of sound and prudent management in its dealings with UAE Exchange, are incapable of giving rise to any arguable defence to the claim against Dr. Shetty under the guarantee. And then he sets out, and I don't want to read all this out, but it is important that your Honour should read it. He sets out an extensive quote from Bank of India Patel. The true principle is that while a surety is discharged if the creditor acts in bad faith towards him, or is guilty of concealment amounting to misrepresentation, or causes or connives at the default by the principal debtor in respect of which the guarantee is given, or varies the contract between him and the principal debtor in a way that could prejudice the interest of the surety, other conduct on the part of the creditor not having these features, even if irregular and even if prejudicial to the interest of the surety in the general sense, does not discharge the surety. And he comments on the modification of the general and by the particular. And then at paragraph 133, I quoted this in my skeleton. The significant point is that in the absence of bad faith, misrepresentation or connivance in the principal debtor's default, irregular, prejudicial, or negligent management by the principal creditor of the relationship with the principal debtor does not discharge the surety. And then they say, he says at the end, Dr. Shetty's representatives have not been able to point to any authority contrary to the decision in Patel, or to identify any known legal principle which would sustain the proposition that a failure by the principal creditor to take reasonable care to protect its own financial interests somehow discharges the liability of a surety. Now, although it's somewhat obscured by the print, it says similar considerations apply to the assertion that Barclays was in breach of its regulatory obligation of sound and prudent management. There is no reason in principle why such breach, if established, should have any effect on Dr. Shetty's obligations as guarantor or under the indemnity which he granted. And his representatives have not produced any authority or identified any principle of law to support the proposition that the conduct by Barclays which might place it in breach of its obligations under a regime of prudential regulation somehow discharges either UAE Exchange's liability to Barclays or Dr. Shetty's liability as guarantor and indemnifier of loss. Indeed, the proposition is inherently perverse. He says the proposition is to the effect that breach of a regulatory obligation of sound and prudential management imposed to ensure the continuing financial stability of a financial institution should be construed as having the consequence that the liabilities of the relevant institution's debtors and sureties are discharged, thereby weakening the solvency and stability of the institution. It is not surprising that no authority has been provided to support this extraordinary proposition. In summary, as neither negligence nor breach of regulatory obligation would have established give rise to any defence to Barclays' claim, there is no reason to order a trial in order that those issues could be explored. So we submit that the same reasoning applies with equal force in the present case.
Yes.
And coming to the final points of my submissions, Your Honour, there are some submissions of English law made by Mr. Shaheen on page 1549, paragraph 94. Now, English law doesn't apply because, as we've seen, the UAE exchange is expressly governed by DIFC law, and the NMC exchange, the NMC health guarantee is governed by UAE law. So it's irrelevant, but essentially, there's reliance placed on the statute of frauds, an English act, which is very well known, requires guarantees to be in writing. I mean, they are in writing, so that doesn't present a problem. And the other point made by Mr. Shaheen is at paragraph 99. He refers to Holman Brunskill, essentially that a variation without the guarantor's consent, which could prejudice the liability of the guarantor, shall lead to the discharge of the guarantee. Well, obviously there was consent to the variation in the UAE exchange case because we have 3 different personal guarantees signed by Dr. Shetty. And in any event, as we've seen, there's that boilerplate wording intended to prevent the application of this principle. Guarantees invariably include a form of wording designed to preclude the operation of the rule in Holman Brunskill, and they do so in this case. So in summary, Your Honour, I ask you to find that defendants have not shown any real prospect that they will successfully defend the claims and that there is no other reason for the claims to go to trial. And I ask the court to enter judgment for the bank against Dr. B.R. Shetty in the sum of 44,102,955.90 US dollars in respect to the NMC healthcare guarantee, and against both defendants jointly and severally in the sum of USD. Sorry, I got the right figure. Sorry, I gave you the wrong figure. The NMC figure is it's USD 37,370,455.50. The sum sought against both defendants jointly and severally in respect to the sums owed by UAE Exchange is US dollars 44,102,955.90. If there's
where do I see those two figures?
You'll see them in the interest claims at the very end of the bundle. What I've done is because those figures include legal costs inappropriately, I've deducted figures. It's at 1915 and 1916. If you go to the bottom of 1915,
I see.
That's what I've simply deducted the legal charges of 208, etc.
So 1915, that is the NMC figure.
That's right. And the one and the bottom and the next one on 1916 is the UAE exchange figure. And again, the figure I gave you subtracts the figure claimed for legal charges. I mean, those are claimed, but they're not part of the interest calculation.
No. All right. Well, if Mr. Shaheen doesn't accept those figures, are you in a position to verify them?
Yes, not instantly, but I would ask for the, of course, we can put in a witness statement from the person who made the calculations.
Yes, well, we'll see if Mr. Shaheen accepts the figures or not.
So I would just say that if there's any point I've not addressed in Mr. Shaheen's argument, I will obviously address it in reply. Thank you very much. But those are my submissions, Your Honour.
All right. Well, thank you very much. It is now, my calculation, 33 minutes past the hour, whichever hour it is and wherever you are. If we now adjourn for approximately 20 minutes and return at 55 minutes past the hour, wherever you are.
Thank you.
All right, Mr. Shaheen, is that, do you understand that? So we come back at 5 minutes before the hour.
Yes, Your Lordship. Thank you. Your Lordship.
All right, thank you. Now, just before I go to you, Mr. Shaheen, Mr. Sullivan, you've taken me to those two schedules in the papers which show amounts outstanding claimed in each action. Now, whilst I will make every effort to make a decision, deliver a decision as soon as possible, I'm not sure when that will be. Is there a daily rate of interest accruing?
There is. I don't know what it is. It may be pleaded. I have a quick look at the particulars of claim.
Well, we might come back to that. I'll hear from Mr. Shaheen because it may well be that I'll be asking you to verify, put on a witness statement to verify those two amounts that you've taken me to in any event. And if that's to be done, then you could also include in it on the assumption that a daily rate, yes. All right, well, thank you.
Yes, there is actually, I just look at NMC Health, for example, page 41.
Yeah.
It's actually, it was quite a lot of money. It's said to be USD over 4,000 per day interest. And on top of that, 1634 penalty interest. So that's the NMC Health.
Yeah. Okay.
And it's and there'll be a similar provision in relation to UAE exchange, which I can refer you to. Yeah.
All right. Well, Mr. Shaheen, it's your turn now.
Thank you very much, Your Lordship. Thank you very much, Madam Sullivan, for your submissions. At the outset, Your Lordship, it's a basic principle of natural justice. Audio altrum part. Nobody should be content unheard. Being heard means sufficiently heard, and that requires a trial. So any application for an immediate judgment is an exception. That's not the rule. An exception has to be applied very carefully, is my humble submission. And that is warranted only in the rarest of rare cases because it's exceptional circumstances. If we go by the arguments raised by the learned counsel, it appears that in any case filed by the bank against a borrower or a guarantor, there is no trial required at all. Immediately, a judgment has to be issued. That's the way the matter has been presented. Unfortunately, that should not be the case because it goes against the very principles of natural justice. Now, if at all there is one case, even if all the cases filed by various banks against the borrowers are to be judged immediately without trial, if there is one case that should not be, it's exactly this one, Your Lordship. Because of the nature of the case, the way the claims are presented, and the claims are not proven, neither admitted nor proven. The principle is an admitted fact need not be proved. Here, the case against the first defendant, who's the borrower, has been stayed. The amount is not determined. And without determining the liability of the principal debtor, how can a surety be held responsible for any amount? I'm not saying that a surety should not be sued independently. A surety can be sued independently, even without suing the borrower being sued. I agree with that. But the liability has to be determined. Either it should be admitted or it should be determined after a trial. This is my submission, Your Lordship. One argument could be the liability of the guarantor is independent, separate, whatever. Still, the liability, what is guaranteed by the guarantor is the liability of the principal debtor. That has to be determined on the first place. Second, the liability of the guarantor is simultaneous and coexisting. So something to be simultaneous, there has to be a liability of the principal debtor on the first place. Coexistence always requires two liabilities. And the first liability is always the liability of the principal debtor, which is neither admitted nor proven in the instant case. Now coming to the case, Your Lordship. First and foremost, a guarantor can only allege chances of forgery. He cannot be asked to prove the instance of forgery by itself because forgery doesn't happen in front of his eyes. So he can only say that I have not signed or I don't remember having signed a document like this. My signature might have probably been misused or abused either by digitally copying it and placing it on another document, or something I signed is taken from there and stapled together with some other document. That's the maximum he can allege. He cannot say.
Mr. Shetty hasn't done those things, has he? He has not given a witness statement in which he says, I did not sign these documents. He has not given a witness statement where he says it's not my signature. He's simply not gone that far.
It is in the statement of defense itself, Your Lordship.
Well, he didn't sign that.
It's on his behalf by a duly authorized attorney acting on his behalf. So it is before this honorable court the fact that the personal guarantor is not admitting his signature. And he requested the honorable court for appointment of an expert, which this honorable court was kind enough to allow. And an expert was appointed. And the expert visited the bank's premises, inspected the document which was presented to him. And I will take Your Lordship through those findings shortly.
All right.
First of all, Your Lordship, we can directly look into that particular personal guarantee, which is page number 76.
Yes.
If Your Lordship look into this personal guarantee, first page, it's written execution version on top. It's not on the letterhead of the bank. It's not on the letterhead of the borrower or the guarantor. It's on a plain white paper. Nobody has signed that document. There is no signature. There is no initial in order to be verified. There's absolutely nothing. I can type one like this today. And same is the case with pages 2, 3, 4, 5, and 6. those 6 pages do not bear any stamp, any letterhead, any signature, any initial from anybody, neither from the bank nor from the personal guarantor. So what evidentiary value would these papers carry? Now,
well, the bank officer, Mr. Shaheen, the bank officer says, I witnessed this signature to this document. The bank has been in possession of the document. So if those first 6 pages do not form part of the document that was signed on page 7, that is to say that the bank or some of its officers engaged in the fraud of placing the page 7 at the end of 6 pages that were not presented to Mr. Shetty. Now, there's not been any, that's not been suggested, it's not pleaded, it hasn't been said at any time by or on behalf of Mr. Shetty that the bank engaged in some forgery or fraud. The only suggestion in Mr. Shetty's documents are that it may have been done by somebody within the company, not by the bank.
Yes, Your Lordship, you're right. It can be by the company, somebody it is specifically pleaded. It could be by the bank. It could be a joint effort also. We don't know. But all that I could ask this Honorable Court is to appoint an expert. And the expert has given clear findings on these 6 pages. I will take Your Lordship through that. Now, the last page, again, the execution version is written on top. All that is written on that page is, this guarantee has been duly executed and delivered by the guarantor as a deed on the day and year first above written. That's all. So why the signature of Dr. Shetty on the last page was not verified? Even if it is verified, all that can be proven is 1.5 lines, which says this guarantee has been executed.
Well,
it will not.
Mr. Shaheen, what is the defendant's case? Is it that he never signed that page, or is it that he signed that page and it was added to other pages that weren't present when he signed it, or what is his case?
It's a combination of both, Your Lordship. He says, I don't remember having signed any personal guarantee in favor of this bank, first thing. My signature could have been misused or abused by copy pasting it or someone imitating my signature. It could be either by someone who was in the management of the company, all those people who are on the run, and there are serious criminal cases filed against them before various courts across the globe. They have not been apprehended. And they played the fraud, and that resulted in the fall of the entire empire. My client, whom I represent, Dr. Shetty, as rightly mentioned by Madam Sullivan, was a very prominent businessman here with an untainted reputation. He had hundreds of companies within the group, hundreds of hospitals alone within the group. It's impossible for a person at that stature to remember clearly what exactly are the documents he signed on each date.
Even a loan documents and mortgage for $50 million?
He refused to admit. He said, I don't remember, I have not signed. He was honest enough to make that statement. He did not falsely point out a finger at somebody saying that he forged, I believe this man, he did not say any of that. He said, I don't remember. This needs to be examined. So the forensic expert who verified the document has come to certain conclusions.
Confirmation letter, if we will have, okay, policy sahi hai.
It's not me. Somebody else.
I'm sorry. Try again, Mr. Shaheen.
Yes, Your Lordship. So he understood the matter and stated that even if the signature is verified on the last page, it doesn't prove anything beyond these 2 lines. the other pages don't bear anything and it's not admitted. See, the general saying which I mentioned initially, an admitted fact need not be proven. It means to say that anything that is not admitted has to be proven also. So the bank has not taken any step other than the self-serving witness statement of one gentleman, which has been refuted subsequently. And I haven't got a chance to cross-examine that.
What's been refuted? Are you talking about now? Which document are we looking at? Which one was this? Is this the NMC or the UAE exchange?
NMC, Your Lordship, because
NMC.
UAE exchange, I'm not going.
So Mr. Who was it? This one was
Dr. Shetty.
Yes, but the bank officer.
It was, Your Honour, it was Mr. Srinivasan. Whose witness statement begins at page 64.
Yes, thank you. So Mr. Srinivasan has put in his witness statement that he was present, he witnessed the statement and he signed it. Now, did you say that's been refuted?
Yes, Your Lordship, in my subsequent submissions, it has been refuted.
Where?
In my notes of arguments, the skeleton arguments, and the second witness statement also.
So who will take me to a witness statement which refutes it?
Sure. I will take it and I'll show it, Your Lordship.
Yes.
We have clearly refuted that. And even only documentary evidence produced before Your Lordship is the photograph. And that photograph was...
Well, I wanted to deal with Mr. Srinivasan. I'm not talking about a photograph at the moment. What I've got, I have a witness statement from Mr. Srinivasan, which says, I was present. He gives us a description of it being an important event and the lead up to it, and him being there present, and him witnessing Mr. Shetty signing the document. And he says, this is the document that Mr. Shetty signed and that he witnessed. Now, you said to me that that's been refuted. Could you take me to where it's been refuted?
My colleague is taking it. I'll present it as an... I don't want to lose time. So...
Well, let me just make sure you don't let it go, because that is a critical piece of evidence. At the moment, I've got Mr. Srinivasan saying, excuse me, I witnessed it. It was signed by Mr. Shetty. I witnessed it. If there is evidence against that, then I need to know it.
Definitely, Your Lord. I'll not let it go. I'll definitely present it. It's important for me as well. So, right. If you look at this guarantee form as presented before the Lordship, the first 6 pages, as I mentioned, no initial, no signature, no stamp, no letterhead, nothing is there, anything can be added. And the expert clearly found that.
Well, the expert says nothing more than I can see by looking at it.
Yes,
there is no letterhead, that there is no other initials on those pages.
And one important point, Your Lordship, which the expert brought to light, even that could have been seen by plain eyes. So that is why before taking Your Lordship to the expert report, I wanted to show the form of the guarantee itself. Right. What is the execution and what evidentiary value can it carry? Now, the expert said that the pages have been restapled numerous times, and the photographs were also produced along with the expert report. That means it's not even in the original stapled form, if at all there was an original document, 7 pages stapled together, and the final page signed. Any important document, like Your Lordship rightly mentioned, a personal guarantee for $50 million, any notarized document, anything, it will contain some form of an arrangement that the pages cannot be tampered with. There is a stamp.
Well, Mr. Shaheen, I would, it seems to me a logical inference that the pages would have been separated for the purpose of copying them and including them in the witness statements, in the bundles that are presented to the court. That is standard, and what would expect that you take the staple out to be able to copy the pages of the documents. For the moment, I can't see anything nefarious about that.
Attributing too much trust on one of the parties to the dispute, Your Lordship.
Pardon?
It's attributing too much trust on one of the parties to the dispute. We deserve an equal treatment. And
no,
therefore,
I'm not attributing any trust, Mr. Shaheen. I'm just saying that the fact that the document has, that a staple has been removed and it's been restapled, that'd be the case, seems to me to tell me nothing, because it must have been removed if for no other purpose than copying it for the court documents. So the fact that it's been, almost all things are possible. But they say only death and taxes are certain. Almost anything else is possible, but that doesn't create any real evidence that it happened.
Must have been for the purpose of copying is just one of the possible assumptions, Your Lordship.
Yes.
There are 100 assumptions possible on the other side. Here, first of all, a $50 million worth of guarantee, not signed on all pages, no stamp, even the bank stamp is not there, even the bank's officer has not signed. So anything is possible. And the person whose signature is allegedly placed on the last page is saying that, I don't remember signing a guarantee of 50 million. So the burden of proof is heavily on the part of the bank to prove that it is exactly this document which this alleged personal guarantor has signed. And that's exactly where they fail. I have said, I don't remember, I have not signed. Okay. And see, this last page, Your Lordship, does not even contain a date. It could have been signed for another facility as a guarantor where the facility amount was only 1 million dirham. And that page can be taken and put together with other 6 pages to show that it was a guarantee given for a 50 million facility, a $50 million facility. So this is the allegation made, and no attempt on the part of the bank other than Mr. Srinivasan's, I would call it self-serving witness statement, and I haven't got a chance to cross-examine this witness yet. And without a trial, I'm being denied of that opportunity. And the place where I have refuted it is page 524, paragraph 1.
Sorry, what was that? Page 524. I'm sorry, page 5.
Mentioned in Mr. Shetty's statement of defense, paragraphs number 4 and 13 of Dr. Shetty's SOD. Mr. Shetty had no knowledge of the arrangement that purportedly gave rise to execution of the disputed facility agreement.
So this is in the defense, is it?
In the witness statement, Your Lordship, my witness statement.
In your witness statement?
Yes.
You need to unlock your iPhone first.
Excuse me.
So he concludes in that paragraph what is stated, Mr. Shetty has always maintained his stance that his signature has been misused.
All right.
So now the restapling of the document, as Your Lordship rightly pointed out, there is one possibility, it was probably for copying. And for copying, it can also be done by folding the document like this and putting it on a photocopy machine without removing the stapler. That's another possibility.
It could be, but then I would probably, my experience is when you do that, you can see the shade in the top right, left-hand corner, but in any event, it's all supposition.
Yes, Your Lordship. My submission is, Your Lordship, the burden of proof is heavily on the bank
Yes.
to prove that they had a personal guarantee duly executed in a form that is enforceable, which cannot be challenged in the future. And if a challenge comes, again, the burden gets reinforced. It is for them to prove, not for me to prove that the unsigned papers were there. Even if I had signed, Your Lordship, how am I supposed to remember what was those first 6 pages? And any other corroborative evidence, like the bank sending the same document by email to Dr. Shetty, confirming that here is a set of document which you signed yesterday. Okay, nothing of that sort. No electronic evidence here, other than the self-serving witness statement, whom I definitely need to cross-examine. And I believe I am entitled to that right as a defense counsel. I should not be denied that opportunity in all fairness. In the interest of justice, I need to cross-examine that witness to bring out the truth. And about the letter of confirmation dated 7th August 2017 and the letter of undertaking dated 7th August 2017, which the bank's counsel today says they are not relying on it, but these are documents produced by the bank. And it is clearly stated in the expert's verification, the summary of finding in both letters is that both letters were pre-signed by Mr. Shetty on blank papers and were misused. This is the finding.
Well, are you going to take me to this expert's report? You've referred to it a couple of times, and I can't see any basis. I've read it before. I couldn't see any basis for the expert arriving at that conclusion.
It's very obvious from the piece of paper itself, the spacing of the letter, the signature far below the content, and it's seen that it is pre-signed. It's not a document.
What leads to the conclusion it was pre-signed?
Because of the way the letter looks, he examined the document, and that is his finding. And that nothing is produced by the bank.
What is it about his examination of the letter that leads to the conclusion? What is the reasoning from his observation to his conclusion that it was pre-signed?
Mainly the spacing of the paragraph and the space left between the signature and the content.
I see.
So, Your Lordship, again, nothing to refute the finding of the expert before this honorable court. And the bank is also saying they're not relying on this document, but it throws light to the nature of handling the documents by this claimant. The way the documents are manipulated. If these two documents can be manipulated, the presumption should be the other way around, Your Lordship, rather than assuming that it was for copying, they would have restapled. It was for changing the pages or putting something else there instead of the real documents that they have restapled it many times. That's the possible inference drawn.
This is not an accusation that you've made in any of your in your defense or your witness statements. You've not there made any accusation that the bank did that, have you?
Directly raised, Your Lordship, my signature has been misused. That's the meaning of it.
No, by the bank.
Yes, by the bank or by the company's management.
Well, yes, I understand by the company, but has it ever been suggested,
yes,
ever been said or suggested that it was done by the bank?
Yes, Your Lordship. Combination.
Where is that?
Show me that, please. I'll find it out and I'll bring it to Your Lordship.
Yes, please.
So that's about the veracity of the document. Now, coming to the nature of the guarantee, even assuming for argument's sake that the guarantee was duly executed, unsigned pages are also binding on parties. If you go to that extended presumption also, this page number 76, Your Lordship, the guarantee form.
Yes. Yes, I have
that. Whereas, pursuant to the terms of the facility agreement dated on or about the date of this guarantee. There is lack of clarity there itself. Which facility agreement? There is a facility agreement produced which is of the same date. If the guarantee was being signed on the same date, what prevented the bank from typing the date there? The date of this guarantee is typed 7th day of August, August in capital letters, 2017. Nothing, the date of the facility agreement is not mentioned. So which facility agreement are you referring to?
Well,
This
it says on or about the date of this guarantee. So it's on or about the 7th of August, 2017.
What prevented the bank from typing the date there is my question. Why this vague statements there? And then entered into between NMC Healthcare and the bank as a lender. The bank has agreed to extend an overdraft facility to borrower for an amount of $50 million. That's how it reads. Now, coming to 1.1. So who is the borrower here, Your Lordship? NMC Healthcare LLC is the borrower, right? And the defined term is borrower. But when we come to 1.1, paragraph number 1.1, in consideration of the bank entering into or agreeing to enter into, bank entering into or agreeing to enter into the facility agreement with the borrowers is in future tense. It gives the impression the facility agreement is not yet entered into. And with whom? The borrowers is plural. Borrowers is not a defined term here. I have to put this document to strict scrutiny because this document is being refuted, completely disowned by the person allegedly signed it, and no signature, stapled multiple times. The chances of tampering is very high, and therefore I am putting the document to strict scrutiny, Your Lordship. Here, the term used is borrowers. It's not just one typo. That's in the second line. If Your Lordship, go to the fourth line. Again, it's borrowers. Fifth line, again, borrowers. And the word used next one is have. Plural again. And what does it say? When does the guarantor's liability kick in? Are obligated to pay to the banker under the facility that the borrowers shall have failed, omitted to pay when due. The language is, this is more like an SBLC, a standby letter of credit. First, there has to be an obligation proven against the borrower. The borrower should fail or omit to pay that money. Then only the guarantor becomes liable. It's not in the form of an indemnity here. The wording is, in consideration of the bank entering into or agreeing to enter into the facility agreement with the borrowers, the guarantor...
What about paragraph 10?
1.1, Your Lordship.
Yes, but you said there's no indemnity. Isn't paragraph 10 an indemnity?
That's a separate one. I'm reading paragraph 1.1. What was the purpose of this guarantee? Here, in consideration of the bank entering into or agreeing to enter into the facility agreement with the borrowers, the guarantor hereby irrevocably and unconditionally guarantees and promises to pay on demand to the bank any and all sums of money that the borrowers are obligated to pay to the bank under the facility agreement that the borrowers shall have failed, omitted to pay when due. This is what it says. In accordance with the terms of the facility agreement, including but not limited to all costs, charges, etc. Now, the terms used in the facility agreement is very important here. What is due? Whatever is due in accordance with the terms of the facility agreement. If there is something due, which is proven to be due or admitted to be due, and they fail to pay, then the guarantor is liable to pay, is the language here. Now, when we examine the facility agreement itself, Your Lordship, there is first of all a definition of an account here. Means
so what page is that? What page is the facility agreement?
Page 84, Your Lordship.
Thank you.
Okay. And the second page, after the cover page, the table of contents, the first page there, 1.1, account means in relation to the facility, the current and operational account established by the borrower and maintained with the lender. That's the definition of the account. Now, facility limit means, that's in page number 25, is written there. It is the first, second, third or fourth page there.
So which page are you on?
Is on the bottom of the page is 25. It's written there. It must be 84, 85, 86, 88 probably.
Right, thank you.
Facility limit means, first A, for a period of 12 months from the date of this agreement, $50 million. So $50 million is only for a period of 12 months. After that, thereafter, $50 million will be reduced by 20% each year till the final maturity date, and such reduced limit shall be facility limit. So if the facility amount of $50 million has to reduce by 20% every year, starting from 2017, in 5 years time, 2022, there should not be any limit available after that. So this is the wording of the facility agreement. Now, final maturity date means the date which falls 5 years after the date of this agreement, except where such date has been extended at the sole discretion of the lender. Now, finance document. Finance document is defined as this agreement, any security document, and any other document designated as such by the lender, and each such finance document as amended from time to time. And financial indebtedness means any indebtedness for or in respect of, there are so many items A to K there. And then going to the page, which was the page number? Page number 58. 90, I believe. Definition of net debt. Net debt means at any time the aggregate amount of all obligations of the borrower for or in respect of financial indebtedness reduced by the bank and cash balance at that time, but so that no amount shall be included more than once. This is the definition of net debt. I'm not entirely clear about this definition. Outstanding amount, there is a different definition. Then comes the definition of personal guarantee, which is very crucial. Personal guarantee means the guarantee to be provided by the personal guarantor in favor of the lender to secure the obligations of the borrower under the finance documents. So what are the finance documents, Your Lordship? Once again, I'm taking Your Lordship's kind attention to page number 88. Definition of finance document means this agreement, any security document, and any other document designated as such by the lender, and each such finance document as amended from time to time. This is why we are calling the personal guarantee given as an all monies guarantee, which is not enforceable even by the decision rendered in the velocity case by Justice Lord Lemiere. Your Lordship asked me about the bank's possible misuse where we have alleged. It's in page 524, paragraph 3, end of it, my witness statement.
Sorry, 534.
524, and the paragraph starts, and in 525 it continues. There still exists a very real possibility that one or more individuals from the borrower's management misuse Mr. Shetty's signature with the support of the claimant's officers, violating their fiduciary responsibilities. So there is a collusion alleged. We did not make any overstatement, but we have clearly stated that possibility is pleaded. One more page I would like to invite Your Lordship's attention. It is 91 probably, Article 1.2, subclause 6 of the facility agreement.
Sorry, 91 clause 1.2.
Construction and item number A6, Roman letter 6.
Yes.
A finance document or any other agreement or instrument is reference to that finance document or other agreement or instrument as amended, novated, supplemented, restated, or replaced, and includes any increase in extension of or change to any facility made available under that finance document or other agreement or instrument, and including any waiver or consent granted in respect of any term of any finance document. It's very open-ended, and that's precisely why we say it's an all money guarantee. Because what the personal guarantee definition says is that means the guarantee to be provided by the personal guarantor in favor of the lender to secure the obligation of the borrower under the finance document. And finance document definition, I invited your Lord's attention to that. And the construction of finance document, this is how it is stated. So anything, everything under the sky.
Just remind me, Mr. Shahini, is this the guarantee in relation to the NMC or the UAE exchange?
NMC, Your Lordship.
Right.
It's all
Now,
about
which is the one which is governed by UAE law and which is governed by DIFC law?
the NMC document is said to be governed by the laws of UAE. But again, it's on page number 6. But all I can do is what is available in front of me is
Yes,
this
thank you.
document. And
Yes.
UAE exchange, we have not reviewed that seriously because I'm insisting on appointment of an expert first to find out the signature, veracity, other details of it, and only then
You've had an expert carry out an examination.
Pardon me, Your Lordship?
You've had an expert carry out an examination.
Yes, exactly, if at all happens. It has not happened so far.
No, you have. You have.
No.
You've shown me an expert report. An expert has carried.
Only on NMC document, Your Lordship.
Yes, but he could have. He's had the opportunity. He could have examined both. You could have examined them both.
It was not made available.
Did you ask for them?
Our application was for both.
Sorry?
Our application was for both.
Yes.
Both we had submitted at that time. This was not combined. The cases were separate.
So
The inspection took place only for NMC.
Yes. So just explain to me. You asked for both to examine both, did you?
Sorry. Yes, Your Lordship. There were separate
Yes.
applications in both cases. We wanted
Right.
to examine the documents to be examined by a forensic expert.
Yes. And were you permitted to examine both?
Only in one, NMC. The other one is pending.
What happened about the UAE exchange? Did the bank's lawyers say you couldn't examine them?
We haven't got a chance to examine it. There's nothing happened after that. Application is before
What do you mean you haven't had a chance? Have you asked and been refused, or what?
That case, we didn't even reach that stage, Your Lordship. We submitted the application and the application is there.
What happened to the application?
Nothing has happened to my knowledge. It's just there in the court. By the time the immediate judgment application came.
And you've not pursued it, you've just sat back.
No, Your Lordship, we opposed the immediate judgment application. There are serious...
No, you say you want to examine the UAE exchange documents. So I understand that you've said you've applied to examine them.
Yes.
And nothing has happened about your application.
Nothing has happened, and whenever we got a chance in the witness statement, in the skeleton arguments, we have insisted, reiterated, those documents are to be examined by the expert, and once examined, similar anomalies will definitely be found.
Right.
And the governing law of the facility agreement is also UAE law. This is which page number? The facility agreement of the as per Article 31, governing law is the agreement and all matters arising from or connected with it are governed by the laws of UAE. So now regarding the NMC case, I'm straight going into those statements, the schedules which my learned friend produced on Friday. That was as far as working days are concerned yesterday. It was just the weekend in between. I'm refuting it, rejecting it completely, outrightly.
So what, these are the schedules of the amounts that the bank says is owing. Is that what you're referring to?
Yes, Your Lordship.
Right.
And again, this is the NMC document is page number 1915.
1915.
No stamp, no signature, no letterhead as usual. Now, it starts from the date 1/6/20. I don't know why. The claim form was on 28/9/2020. The amount mentioned there was 30,104,225 and 6. I don't see that amount anywhere here. This is on a day, starts on a date prior to that, which is 1/6/2020. Claim form was 28/9/2020. Now, finally, there is an amount, legal charges 208, which my learned friend is saying is not included, but the number is shown here. And the last amount shown here is 37,578,693.65. See, the amount it goes on increasing. And that means interest is added every day. And how interest is added in any kind of account, if credit and debit entries are to be made, it has to be a current account. In this particular document, even the account number is not mentioned. So it is clear under the laws of UAE, a current account has to be closed. Article 390 of the UAE commercial transaction law. A current account has to be closed. Only then the amount becomes due for payment. Until then, it is only a debit or a credit entry, determining the rights of the parties at the closing of the current account. Only the amount at the final closing of the current account is an amount due for payment, is the language of Article 390. It's very clear. And the facility agreement is governed by UAE law. The account is defined as a current account. I already mentioned that when I was referring to the document. It is in page number 85. Account means in relation to the facility, the current and operational account established by the borrower and maintained with the lender. Governed by UAE law is stated in their own facility agreement. And Article 390 of the Commercial Transaction Law number 18 of 1993, very clearly stipulates that only the amount at the final closing of the current account is an amount due for payment. And this has been brought before this Honorable Court by the judgments cited by the claimant. The purpose of citing those judgments were different, but it is there in those judgments in the dictum which they have presented. The current account has to be closed in order for any amount to be claimed from the borrower or anyone related to the borrower, because the amount is not due for payment until then. If any bank files a case before closing the current account, that claim is premature and is liable to be dismissed. So here in this case, before this Honorable Court, there is absolutely no evidence to show that the current account is closed, first of all. Second thing is that there is
Mr. Shaheen, I can't immediately see where it is in my notes, although I took a note. Some stage, Ms. O'Sullivan showed me that the account had been closed, I thought.
It is, see, the evidence to the contrary I'm saying is because they are calculating interest. In the table produced by them yesterday, according to me, Friday, it's clear that they are still calculating interest on it. If a current account is closed and that's the amount determined to be paid, how do you add interest every day on that account unless the current account is running? Now, if the current account is running, if someone pays some money into that account, that will also be credited there. The account is not closed. It's premature, the claim. Even the borrower is not liable to pay.
So do you say that the bank must close the account and then claim the amount that is the balance at that time, and it cannot claim for any interest after that date.
Yes, Your Lordship. After that, the matter is before the court and the court awards interest, either based on the agreement between the parties or as determined by the court. This is the normal practice in the mainland courts because this is a facility agreement which is governed by UAE law. So we have to follow the UAE federal laws in respect of this facility. So
well, isn't this schedule just showing the amount the bank says is the amount of interest after the account was closed? Is that what it's saying?
It's not possible that way, Your Lordship. Once the current account is closed, that's the relationship on the basis of which there is a borrower and a lender relationship established between the bank and the borrower. There's no other document to start with. First starting point is the current account, and that's exactly how the facility agreement is also worded, first definition of the account. So that account has to be closed, and on the date when they close the current account, they have to stop charging interest there. Then further interest is as ordered by the court. So my first contention is that the bank's claim is premature. Even the borrower is not liable to pay any money here. Second contention is, even if, assuming for argument's sake that it's not premature, either the amount ought to have been admitted or the amount ought to have been proven against the borrower in order for the liability of the guarantor to kick in. Even if it is joint or several. Joint means one liability here and another person's liability is joined to that. Several also requires two liabilities there. Even if it is simultaneous and coexisting, whatever way we try to word the personal guarantee, the liability of the borrower has to be determined. I'm not saying that they have to first sue the borrower, exhaust all their remedies and only then come against me. No, that's not my argument, Your Lordship. My argument is amount has to be determined, either admitted or proven, which has not happened in this case. So first, premature. Second, amount not admitted, not proven. There is no liability to be satisfied by the personal guarantor, even if the alleged disputed personal guarantee is enforceable. That's my primary contention here, that personal guarantee is not enforceable. I have no idea about the first 6 pages, even if it is admitted, or for argument's sake that it is my signature which is appearing on the 7th page. And Your Lordship, if we look at the prayer portion in the skeleton arguments, what is submitted by the claimant, item number 64, the last one. It is stated that for the above reasons, the defendants have failed to show that there is any real prospect of them successfully defending the claim. With all the submissions that I made, Your Lordship, and all the 21 pages of defense they had to put in, is it not evident that I have a real prospect in successfully defending the case? Am I obliged to prove on the first hearing that the entire claim of the bank is void and I have succeeded now? Then I'll be requesting for a reverse immediate judgment. Here, what I'm opposing is the immediate judgment application submitted by the bank. All that I need to provide before this honorable court is that I have a prospective defense here. So the form of the guarantee itself is sufficient enough to prove that I have enough elements here to defend my case. The only place where my signature is allegedly placed is on the page number 7. The 6 pages, I'm saying I did not sign, I have no knowledge about it. So that itself is a good prospect in defending this case. Now, prospect of them successfully defending the claim, or that there is any other reason why the claim should proceed to trial. And then the request is the court is asked to enter immediate judgment for the bank on its claim. That's the only request is immediate judgment. Now, when we look at the last portion, the concluding portion of the skeleton arguments that is presented by the defendants, first request is, this is on page number 28 and 29 of the skeleton arguments presented by the defendants in this case. First request is dismiss the claims in its entirety against Mr. Biashetty and Mr. Binay Shetty. This is page number 1552, Your Lordship. Dismiss the claims in its entirety against Mr. Biashetty and Mr. Binay Shetty, pursuant to the claimant's contravention of the laws of DIFC. This is one. Second one is according to Article 121 bis of the Central Bank Regulations. Third one is Article 1061 of the UAE Civil Code. Fourth one is dismiss the claim in its entirety against Mr. Biashetty and Mr. Binay Shetty under the applicable laws of England and Wales. So these are the four requests.
What's the relevance of the laws of England and Wales?
I will explain that also, Your Lordship. According to the DIFC rules, I'll explain. So these four prayers, I'm just highlighting the nature of the prayers, why it's four prayers. Right? See, it's an accepted norm, a general principle in any trial that the defense is allowed to take inconsistent alternate pleas. And that's exactly what is happening here. If the first one is true, the second one is not even to be considered. Already the claim is dismissed. I don't need a cumulative effect of all the four. Either one is okay. Any one is okay. There are four, and the word used at the end of each prayer is or. So it is just four possibilities for a reverse immediate judgment. A reverse immediate judgment because after doing all the skeleton arguments, presenting all the facts, the supporting arguments, points of law, findings of the expert, it looked like a fit case for a reverse immediate judgment, and that's how these pleas are taken. And each one is explained separately in the skeleton arguments. Now, what is the other one? The fifth one, dismiss both the immediate judgment applications filed against Mr. Biashetty and Mr. Binay Shetty as the conditions stipulated in RDC Rule 24 have not been satisfied. So this is the direct defense of the request, direct refusal of the request made by the claimant in their skeleton arguments. Sixth one is actually a consequential remedy. Stay all proceedings in the current case against Mr. Biashetty and Mr. Binay Shetty until the liability of the UAE Exchange and NMC have been determined and proved. So this is once this immediate judgment application is dismissed, the natural consequence is that the proceedings against the borrower has been stayed and the liability of the borrower, first contention is that it is premature. There is no liability as of now. Even if there is a liability, it's neither admitted nor proven, and the proceedings are stayed. So only after, since there is no admission so far, only after a fair trial, the liability of the borrower can be determined. And for that, the stay against the borrower, in the case against the borrower, has to be vacated, or until such time, the proceedings against the guarantor before this honorable court also has to be stayed. So that's why I'm saying the sixth request made before the honorable court is for a stay, which is only a consequence of the result of the fifth one, which we believe may come in our favor. The last one is regarding the cost. Again, that's consequential. Now, why we believe that the other laws are applicable? It is paragraphs number 94 in page number 25 of the skeleton arguments. So before that, we also have to refer to paragraphs 46.4 and 46.5 of the skeleton arguments. This is page number 1536, Your Lordship.
And what paragraph of your skeleton?
First, we are requesting Honorable Court to please look into paragraph number 44.
44.
Yes, Your Lordship.
Yes.
The prudential rules do not consider personal guarantees or valid guarantees issued by eligible guarantors to mitigate credit risk. 2. 37 of this is another reference. It is pertinent to note that there is no specific DIFC law governing the treatment of personal guarantees or the requirement of determining the debt of a borrower. Under the DIFC law, we don't find any specific provision relating to treatment of personal guarantees or the requirement of determining the debt of the borrower. So therefore, in the absence of a specific DIFC law governing the judicial interpretation of personal guarantees, a reference is made to Article 2 of DIFC law number 3 of 2004.
But that's not the way the law works, Mr. Shaheen. If the applicable law is DIFC law, then you can't go to that law and say it doesn't have any particular provision dealing with some matter, therefore you go to some other law. The Court of Appeal has decided that.
Yes, Your Lordship. Your Lordship is right. We cannot directly say just because there is no provision here, look at something else. That's not the way, Your Lordship. But here I'm looking at Article 2 of DIFC law itself, DIFC law number 3 of 2004, which sets out the method to ascertain the relevant jurisdiction and governing law for civil and commercial matters. Just looking into the legislative provisions. So Article 2 is implementing a mechanism to identify the applicable jurisdiction for civil and commercial matters in DIFC. And this is what I'm trying to explain under Article 46. Paragraph 46 of the skeleton argument. First, Article 2A of law number 3 states that if there is regulatory content set out in the laws of DIFC concerning the matter, then such law shall be applicable. There's no doubt about it. Once somebody has chosen DIFC law as the governing law, which is not the case in the NMC guarantee, by the way, even if I assume that those 6 pages.
Just wait a minute whilst I find a copy of the law. Just give me a minute.
Very much. Take a copy.
Yeah.
So first I'm referring to Article 2A, Your Lordship, of law number 3.
Wait a minute. Law number 3 of 2004.
Yes, Your Lordship.
Law on the application of civil and commercial laws in the DIFC.
Article 2A.
There is no Article 2A.
There is.
I think you might be talking about, I don't know what you are referring to. I have a copy of the DIFC law number 3 of 2004, law on the application of civil and commercial laws in the DIFC, Article 2. This provides, this law is made by the ruler of Dubai. Article sounds like you might be talking about Article 8 in Part 2, perhaps Part 2, Article 8.
Page number 1575, we have produced it before the Honorable Court.
Where is it? Let me have a look.
575.
Okay, let me just, I'm sorry, could you tell me the page again?
1578 is the page number.
1578. Thank you.
Article 8, subclause.
Yes, 8. Right.
Sorry, I didn't mention Article 8 there. So it's Article 8.
Yes, you said Article 2 in your skeleton, but it's Article 8.
My apologies.
Yes, all right.
So the relevant jurisdiction is to be the one first ascertained under the following paragraph. So there is saying that if there is a regulatory content set out in the laws of DIFC concerning the matter, then such law shall be applicable. What is the applicable law? It will be the DIFC law.
This Article 8 says DIFC is able to apply in the DIFC, notwithstanding any federal law on civil or commercial matters. The rights and liabilities between persons in any civil or commercial matter are to be determined according to the laws for the time being in force in the jurisdiction chosen in accordance with paragraph 2. So you go to paragraph 2 to see which the laws for the time being in force in which jurisdiction are chosen. And 2 says the relevant jurisdiction is to be the one first ascertained under the following paragraphs. A, so far as there is a regulatory content, the DIFC law or any other law in force in the DIFC.
Yes, Your
So,
Lordship. First one is the
so
DIFC
the DIFC law applies.
Yes, Your Lordship. If there is a regulatory content, it is the DIFC law which should be applied according to Article 2A, failing which, this is how the wording is, failing which, then Article 2B there of law number 3 also fails as it states that the law of any jurisdiction other than that of DIFC may be applied if expressly chosen by any DIFC law. That's the second portion, Your Lordship. The law of any jurisdiction other than that of DIFC expressly chosen by any DIFC law. That is Article 8, subclause 2B. And again, failing which, subclause 2C says that the law of any jurisdiction, the law of a jurisdiction as agreed between all the 11 persons concerned in the matter. C. Again, failing which, the laws of any jurisdiction which appears to the court or arbitrator to be the one most closely related to the facts of and the persons connected in the matter, failing which the laws of England and Wales. So if we come to A, B, and C, and if we don't find anything there in respect of the guarantors and the determination of liability of the borrower, then we go to D. And if D is also not possible, then we go to E. So that is where I wanted to invite your Lordship's attention to this law, but I'm really sorry it was referred as Article 2, not as Article 8, subclause 2. That was a typo.
Well, I don't want to read it all out to you, but my understanding is that the proposition you're putting is contrary to the decision of the Court of Appeal in the Industrial Group Limited and Abdulazim Al Sheikh Al Fadi Hamid 2022 DIFC CA 005 and CA 006 decided on the 21st of June last year. I don't know if you're familiar with that decision, but it seems to me it's
familiar, Your Lordship. I'm sorry.
Well,
but what's the dictum, Your Lordship, that we need not look into D and E, or?
That's right. It says that, I mean, I don't want to read you the whole judgment, but the proposition, as I understood it, put in that case was similar to the one you're putting, and at paragraph 120, the court said, we are, with respect, unable to read the waterfall provisions in the manner urged by Mr. Boughton, counsel. In our judgment, Article 8 of the law is concerned with choice of law rules going to determining the applicable system of law rather than the content of that system. So having determined, in that case, there was an argument that's rather similar to what you're putting, that the applicable law was the law of the DIFC, but there was no DIFC law dealing with the tort of malicious prosecution. Therefore, the party said there's a gap, so you go down to the next jurisdiction in the waterfall list of provisions. And the Court of Appeal said, no, that's wrong. If the applicable law is the law of the DIFC, if the DIFC law doesn't have a law dealing with that particular matter, then there isn't one.
I understand, Your Lordship. So my argument was that if the first three fails, it goes to the next one. And if that also fails, it goes to the fifth one. And that's exactly why I quoted the laws of England and Wales as well here.
All right, I understand.
Anyway, alternate pleas which I have taken in the final conclusion, because I could not find anything which is relating to the guarantee. In a proper trial, definitely we will try our best to study that particular judgment as well and try to distinguish if there is a possibility or accept the decision as it is. Again, I'm stressing my humble submission, there is a trial required here. There are contentions, serious contentions raised on facts, on merits, on law, and by the expert. It's not a case to be summarily decreed or dismissed here. It requires a proper trial. There are witness statements submitted, and the witness cross-examination of the witness is the right of the other party. There are witness statements presented before the court, the veracity of which has not been checked. So I just wanted to explain why I went to the laws of England and Wales.
Yes, I see.
Then another Article 7.2 of DIFC Law number 12 of 2004.
But that's to do with execution.
That has to do with execution, and we always look into whether this judgment has to be executed afterwards and what would be the consequence. Are we?
But I'm not concerned. But I'm not concerned with executing the judgment, am I?
Your Lordship is only determining the case on the merits, Your Lordship. I fully
That's
agree.
right. And whether it can be executed or not, that comes later.
The reason why I cited this article is again relating to that waterfall clauses under law number 8 of subclause 2, why UAE law is relevant to this one. The most relevant law, most related law is the UAE law because there is no provision in this one. And in the NMC case, all these applies, Your Lordship, because the law applicable to the facility agreement and the law applicable to the personal guarantee is the UAE law anyway. So it is in the UAE exchange case, the other case which is combined, which should not have been combined because two different sets of laws are applicable. The facts, merits, everything are different here. We did mention that it's not to be combined, but unfortunately, that's the way the claimant wanted it, and that's how it happened. So, Article 390, 391, I already touched upon, Your Lordship, that why it is required as a basic mandatory requirement of the UAE law, as far as the NMC case is concerned, at least. And I was of the view, I believe it is the UAE law to be applied on the other one also, but Your Lordship has clarified that there is a judgment, but when I'm chance in a trial, I can distinguish that and say why it should still be UAE law. And about the all monies guarantee, Justice Lord Glennie, how it was determined that it's an all monies guarantee and not enforceable. It's applicable in the case as well. And it's again under the UAE law, which Lord Glennie looked into it because the governing law of the guarantee there was also UAE law, and here as well in the NMC case. And I have taken Your Lordship through various provisions of the facility agreement itself to show that why it is an all monies guarantee, anything, everything coming in the future between the borrower and the lender. And it's not a determined debt. And about Article 121 also, I agree with my learned friend, that's not to be applied to the IFC, but when the governing law is the UAE law for a facility agreement, Article 121 of the law number 14 of 2008, the central bank regulations, which says that sufficient security should be availed, is applicable there as well. And there are ministerial clarifications given subsequently, giving it retrospective effect also, the law. It's not just from the date of issuance of that law. Anything which has to come to the court, and there are judgments issued by the Abu Dhabi Federal Court, which applied that provision and said the bank has no claim, no lawsuit can be filed, no execution proceedings can be granted. This is exactly what the law says. And at least in the NMC case, it's squarely applicable because that's governed by the UAE law. Now, just responding briefly to the various contentions raised by the claimant in their skeleton argument. First of all, it's just a joke in the league. When you're not able to attack the content, attack the author. So it said that my witness statements are not supposed to have been submitted in the way. See, my witness statement is nothing pinpointed where exactly I crossed the border. It's not a blanket prohibition that a counsel should not submit a witness statement. It is a witness statement is a requirement under the law in various circumstances, but I have not stated anything in my witness statement which is extraneous to the Honorable Court, meaning it's all already pleaded in the name and on behalf of Dr. Shetty and my client Vinay Shetty, and also what is proven before the court through
Does
evidence.
that mean, Mr. Shaheen, that I really need not look at your witness statement if it does nothing except, if it doesn't add anything if it doesn't add anything to the particulars of defence, should I just look at the defence and ignore your witness statement?
Partly true, I must admit. On the facts, there is nothing new, Your Lordship. But I have linked the facts to the provisions of law, being a counsel. And I have given a context to the content of the facts in the witness statements to make it easy for the Honorable Court.
So there are no facts in your witness statement that you rely on, merely propositions of law and how the facts stated in the defence apply to the law.
Exactly, Your Lordship, because I am not a party to I have no relationship with the facts of the case, other than what is told to by my client to me and what is evident in the document produced before the court, which are all either pleaded or produced before the Honorable Court. My duty is to ensure that the court arrives at the right conclusion. So whatever best possible manner I could help the Honorable Court in doing that, I have done it in my witness statements. And the witness statement happens to be a prerequisite in various situations. Somebody has to submit a witness statement. I have done it, Your Lordship, but no extraneous facts. So these provisions which are cited.
By extraneous, you mean extraneous to the particulars of defence?
Yes, Your Lordship. Whatever is stated before the Honorable Court in the statement of defence, what is pleaded with citation reference to that pleading, or the documents evidence produced before the Honorable Court directly referring to that, and then connecting it to the applicable law and the interpretation. This is all what I have done.
Okay.
And violation of the prudential norms. This is, we have stated in our skeleton arguments and it's pleaded before the Honorable Court. There are various steps the bank ought to have taken in discharging its duties. The bank also is not a privileged party here. It's just another party to the dispute. And no party to the case can expect the Honorable Court to perform its duties. When a bank is granting facilities, there are prudential rules given by the DIFC laws applicable there, how that has to be granted, how it has to be monitored. Here we see that the Muddy Waters report, which has completely shaken the empire and the whole thing collapsed, even after 6 months. It takes 6 months for the bank to take any action. Even after that, the bank continues to allow drawdown from the facilities and huge amounts in 20-30 millions to that extent for your exchange. So this is how irresponsible or irrational the lender has behaved. And the bank cannot expect the court to perform its duties. It is the duty of the bank to do that. And this is the spirit of Article 121 also in law number 14 of 2008. What you have to do at the time of granting a facility, it's your duty. If you have not performed your duties properly, honestly, dutifully, don't expect the court to do something for you. Because those who seek equity should do equity on the first place. Those who come to the court seeking equity should come with clean hands. You cannot just lend facilities. And even the guarantor, there are judgments produced by my learned friends saying that suppose the bank is not doing its duties properly, that doesn't mean that the guarantor is exonerated. But suppose the lender is doing something illegal, no right can stem out of an illegal action. A contract, in order to be valid, it has to be legal on the first place. So prudential rules are binding on the bank, and the bank has violated the prudential rules, which I have clearly mentioned in the skeleton argument. I don't want to repeat it again. And see, any guarantor, when he is joining, suppose the alleged disputed personal guarantee is valid and was signed by me, if at all, Why is the guarantor joining the liability, his personal liability, with the corporate? Well, suppose the corporate is buying or taking a loan from somebody else from the street. No guarantor will sign a personal guarantee to that level. It is placing certain amount of trust on a financial institution which is regulated under certain rules, laws as strict as the DFSA, DIFC rules and the prudential rules. It is for that reason that the guarantor is agreeing to join the liability or the applicable UAE laws, the central bank regulations, how the banks are supposed to function. Do everything illegal, completely violate all the rules, do whatever you want, but come back to the guarantor and say, oh, you signed this one. This is exactly what the spirit of Article 121 is, and that applies to the prudential rules also. The bank cannot do something illegal and expect the personal guarantor to cover the bank for everything what they have done. They have not been diligent, they have not been dutiful, they have not been honest, I would say, to that extent, because of the way the personal guarantees are handled, the way the letters of undertaking have been hooked up, and finally, the way the drawdowns were allowed. Even after the Muddy Waters report, when all other financial institutions would have considered these entities as clearly untouchable. And about the fraud, which is the claimant is saying that nothing is proven. We have all that we could do is request the Honorable Court to allow.
Just before you link that, do you want to make, you heard Mr. Sullivan referred to the Barclays Bank and Chetty decision about this point,
Yes,
about the prudential rules and regulations. Do you want to say anything about that?
I'll come to that, Your Lordship. Is it all
right?
So now, Your Lordship, about fraud, allegation of fraud. What can a personal guarantor do? Put ourselves in the position of the personal guarantor. Suddenly, I'm being sued in a case, oh, you were the personal guarantor. I have not signed, I don't remember to have signed anything. All I can do is, where is the original of this document? Please allow a forensic expert to examine it and submit a report. And that's exactly what this personal guarantor has done. And the findings, I understand Your Lordship's point that even a layman could have found all this. It doesn't take a forensic report to unearth these facts. Does it undermine the findings of the expert, or it strengthens the report further? In my argument, I would say it strengthens the report further, Your Lordship, because it's so obvious to plain eyes, naked eyes. It's obvious the guarantee has not been properly executed. It's tampered with. Removing of the staple. I understand Your Lordship's one possible suggestion. I have so many other suggestions which I don't have to say. We all know what it could be. And no signature, no stamp, no seal, and no letterhead, 6 pages without any validity. It has been enclosed with one line, this guarantee signed on a particular date without even the date. So even assuming without admitting that the signature is true, it only applies to that particular line. So allegation of fraud, whatever is the possible step from the guarantor's side, the guarantor has taken in this particular case. There are other cases, Mazrui case, which we cited, saying that we did not do anything as the Honorable Chief Justice found in that particular case, but we did. We did take all possible steps. Nothing more was possible. Now, coming to the other cases, Your Honor. Yeah, again, it is relating to the findings of the expert. It's the GFH Capital Limited versus High. Again, we are saying that the court may give immediate judgment against a claimant or defendant on the whole of claim, part of claim, or on a particular issue if it considers that the claimant has no real prospect of succeeding on the claim or issue. That is probably a possible equation, Your Honor. Considering the kind of guarantee document which has been produced before the Honorable Court, that's very much possible. An immediate judgment is possible. Article 390 Commercial Transaction Law, premature claim, the debt not determined, all money is guaranteed, and the guarantee is not even worth the paper on which it is typed. No signature, no seal, no stamp, and no letterhead. And even the signature on the last page is only for one line. That is 1A of that particular provision of the DIFC law. And second one is that the defendant has no real prospect of successfully defending the claim or issue. It's not successfully winning the case, Your Lordship. It's only about successfully defending the case. Defending is different from winning. Okay, I have a possible defense. I have.
You have to explain that to me. What's the difference between successfully defending and winning?
When I have appointed an expert, Your Lordship, and the expert has come out with a finding of all these nature, which is glaring, very obvious to naked eyes, as Your Lordship put it, and that itself shows I have enough elements to successfully defend this case. First, on the facts. Second, the witness who has been produced, I have a right to cross-examine him, the witness statement. Three, all the provisions of law which I have cited, various provisions of law, including starting from the current account, the closure of it, Article 1061, which is about all monies guarantee, and other provisions of law, which I'm talking about the prudential rules and the 121, CB regulations, all these put together, definitely have enough and more evidence or defense arguments to be placed before this honorable court. Whether those defense will win and ultimately get a judgment, which is actually putting me in a position while defending an application for an immediate judgment, I have to completely prove my case and get a judgment in my favor. This is the difference, I believe, between the successful winning of the claim and the successful defending of the claim. Successful defending of the claim, I have more than that, Your Lordship. Successful winning of the claim, I'm almost there. But if I get a proper trial, proper opportunity, I'm very confident, Your Lordship. It can be a winning case. So that's, I hope I have made the distinction between the two. Now, there is no other compelling reason why the case or issue should be disposed of at a trial. There are several compelling reasons here. Unlike the Berkeley's case, which I'll come into. See, in the Berkeley's case, what were the legal issues pleaded? There's nothing cited in the judgment as what we have done. It's only about the prudential rules, but not about the governing law is UAE law. And there is Article 1021, closing of the current account, Article 390, commercial transaction law was not pleaded there. And the expert appointed as producer report, the expert has to be cross-examined by the other side. It's not enough to attack the expert without even questioning him. And our application for appointment of an expert is pending before the court, which also has to be disposed through a trial. So there are enough and more compelling reasons why the case or issue should be disposed of at a trial. So this is about the immediate judgment. And I'm only citing the factual evidence brought before this honorable court through the expert report in defending the cases produced like Mohammed Mazrui and GFH capital cases were expert report we have produced. So it is there. So there is an arguable case, there is a defendable case, a successful defense is possible. Again, Mazrui case, and realistic defense is one that carries some degree of conviction, not 100% degree of conviction. If 100% degree of conviction, what I would be requesting and insisting for is a reverse immediate judgment. I have mentioned that if the honorable court is so pleased, it should not go without my request. So it should not be at the end saying that the defense counsel never requested for it. Yes, I did request for it, but that's exactly where I came to after while concluding the skeleton arguments in this case. Enough elements to have a reverse immediate judgment. In reaching its conclusion, the court must not conduct a mini trial, that is Swain versus Silman. See, first of all, even if the honorable court is not taking the arguments raised by the defense at face value, what else can the defense do in a given situation like this? Suppose a person on the street is alleged to have given a personal guarantee, and he says, I have not given one. What more can he do? Here, there are certain things some people are prompted to jump into a conclusion because it is Dr. Shetty. He was a very prominent businessman. He was all in all in New Medical Center Group. He was the chairman and executive director of UAE Exchange once upon a time. He would have signed. Without his signature, the bank would not have given. But the allegation of fraud, the conspiracy, I should call it, I don't want to use big words here, whatever has gone through between the management, which has been tainted completely, and the bank's officials. These are the possibilities alleged. This is the maximum the defense can do here, and which has been put forward before this honorable court. And Dr. Shetty was not in management of these companies after 2017, where he effectively stepped down. And afterwards, the new management has been taken place. And it is that management which is on the run, the responsible person.
As I remember it from the documents, after 2017, he was a non-executive chairman.
Yes, Your Lordship. No connection with the day-to-day affairs, no connection with the running of the.
Well, I would think the chairman has got. I think the shareholders would probably be disturbed to hear that a chairman has nothing to do with the running of the company. But anyway.
I said day-to-day running of the company.
Day-to-day running, I see.
So he only chairs the board meetings. That's it. Whatever is presented in form of a manager's report, that's what he sees. The management information systems, MIS, is what he sees in his capacity as a non-executive chairman, Your Lordship. And that's exactly the documents which were presented before the authorities also, even the stock exchanges across the world. And all those were fraudulent. And he was the biggest victim. He was personally the biggest victim of the whole fraud. And he has filed serious claims, hundreds of millions or billions, against the management, against other people.
I don't think there's any evidence of that before me, is there?
Not at all, not at all. See, I'm only saying for a person, since Your Lordship asked me, what is the non-executive chairman's role? I'm only saying the consequence of being a non-executive chairman, how a non-executive chairman can be duped in the same way the management duped the banks and also the authorities here, including the stock exchanges. And that's why criminal action is taken against the management. And even Dr. Shetty is the biggest claimant in the whole of the cases. That's also there. So even the evidence which is required in the UA exchange case, as Your Lordship rightly mentioned, the application is still pending. So that examination of those documents is a major requirement here in order to determine what is the nature of those guarantees. Are the same anomalies what happened in NMC happened there as well? There is some initials there. There are various guarantees, 2, 3 guarantees going from 10 million to 25 million to 35 million. Were all of them properly executed? Even Mr. Binay Shetty has denied having signed anything of that sort. So that needs to be verified. Even the signature needs to be verified because there the signatures are on all pages. And the signatures if you look at it plainly before with the guarantee, first 3 pages I looked at the UA exchange guarantee, there is no similarity between the signatures, entirely different. The 3 signatures on 3 pages of the same person looks so different. So I'm not an expert, so I'm not submitting anything in writing to the court. I'm just making a passing reference here, but an examination is required. An examination of that signature is required. It's unlike the case of NMC. Even if that signature is examined, even if that signature is proven to be that of Dr. Shetty, it's of no consequence because it's like on a plain paper, just one line. All that is proven is that one line is correct, and that one line doesn't mean anything. The first 6 pages, there are no signature to be verified on the first page. So this is about the requirement for a trial and why this case cannot be disposed through an immediate judgment, denying an opportunity to be heard for the defense. It will result in serious miscarriage of justice, is my humble submission, Your Lordship. And sufficient security is a requirement, and that's when the UAE law is applied. There is a requirement like that need to be examined, whether there was sufficient security or not, or if it was just a personal guarantee given, whether that particular Article 121 squarely applies to this case, or if it doesn't apply, for what reasons. There are judgments. Various judgments are cited here in this skeleton arguments by the claimant's counsel also. All this requires a serious trial, Your Lordship. It's not something which can be summarily disposed of. It will be against the principles of natural justice, is my humble submission. Even the judgment which I briefly mentioned by His Lordship Justice Zaki Asmi, the Chief Justice here, he has mentioned, but he must at least adduce something, okay? Some ground, basis of fact that can enable the court to conclude that there is sufficient basis to the claim that forgery had taken place. As I explained in detail, Your Lordship, we have done everything possible in order to help the court to arrive at the right conclusion. All that I could have applied is for appointment of an expert to verify the document, which we have done. And the report is there. It's very glaring. The mistakes in executing a proper document especially when the value is, as your lordship mentioned, $50 million here, and this is certainly not the way. So there are serious allegations there. There is a prospect there. There is a possibility for successfully defending this claim, and we have adduced something, not something, everything that was possible. There is nothing else that I could have done. It was not done under a CCTV camera for me to prove what exactly happened there. And the stay order, your lordship, when a case is filed against various parties, the main party, whatever said and done, is the borrower in that case. The case against the borrower is stayed. So the liability, when we say it's joint, the joint liability also gets stayed. It's about the proceedings before the Honorable Court. If it is simultaneous and coexisting, simultaneous is also stayed, coexisting is also stayed. So there is no reason why this case has to proceed separately, independently. If that was the case, the bank ought to have been filing the case solely against the guarantors initially. Even then, they have to first prove before this Honorable Court this claim is matured after closing the current account, amount is due, and they have to determine the amount, allow the court to determine what exactly is the amount due to be paid. This schedule which is produced now, it even contains amount compounded, meaning compound interest is applied here. This is the implication I'm taking from it. I don't know what exactly they meant, but it looks like compound interest is applied. So compound interest is something which is completely forbidden under the UAE law. And there are several judgments issued by the Supreme Court, various Supreme Courts in UAE, Dubai Supreme Court and also the Abu Dhabi Federal Supreme Court. And the governing law for the facility agreement of NMC is UAE law. The only way whether compound interest is applied or not can be determined, not by my arguments, by appointing a banking expert who is well versed in calculating interest according to the guidelines given by the Supreme Courts here. There is a formula, there is a software to be applied, and it will be clearly seen how much is the compound interest. Even if it is 1 dirham, it is illegal, illegal is illegal. So that gives an indication again, there is an examination required of all their account statements to see whether the bank has applied compound interest or not, especially in the NMC case, because the governing law is the UAE law. And the denial of the signature is not only on the personal guarantee, Your Lordship, it's on all other documents as well. Wherever Dr. Shetty's signature is appeared, he has denied it. So burden of proof is on the party which is asserting that the signature is of a particular person. Because what is alleged is the negative, it's not mine. Negative cannot be proven. It's the positive, whoever asserts a positive thing, the burden of proof is on him. And about the witness, again, only documentary evidence produced is a photograph, nothing else. And that photograph is clearly stated that it was in relation to a meeting regarding express money, which was a remittance scheme which aimed to boost remittances from UAE to India. There was a ceremony and this photo was taken. So once a document is produced, a photograph is produced, it was possible to verify with at least some people who could be contacted. When was this photo taken? So that
what does Mr. Shetty say was the occasion on which the photo was taken?
It was related to express money, Your Lordship. Express money is a product of UAE exchange for instant remittance. You pay here, immediately the money is credited to the beneficiary's account in India. So that's called the express money. Like Western Union, other companies also have similar arrangements. Flash, instant payment mechanisms are there. So
and what was the occasion? It was some promotion about that or something, was it? Well,
so it was about the express money which was being promoted at that time in order to boost the remittances from UAE to India. So there was an occasion, a ceremony going on, and this photograph was taken at that occasion. This is what.
So there was. So in that photograph, what were the documents that were being exchanged and handshakes about?
It can only be something related to express money, Your Lordship. It cannot be this one. Because the occasion is completely different. It's not about signing a document for the bank in the form of a personal guarantee, certainly, which he has denied. He said, I have not signed anything. I have not handed over anything like that. And he remembers that.
He remembers that occasion, does he?
No, he does not remember. To be honest, he does not remember. He had to verify with the people who are also in the photographs and the place where it was taken. What was this? When was this man? And it was.
Where does he say? Where is the statement that that was the occasion when it took place? Where do I find that?
It is in my witness statement I have mentioned about him, and also in the skeleton arguments we have mentioned it.
Okay, let me just try and find it, because it'll be easier for me to find it whilst you're able to help me.
Yes, Your Lordship.
So if you can start with showing me where it is in your skeleton argument, that might help.
We will bring it to your attention, Your Lordship.
Right.
And now, the specimen signatures of Dr. Shetty, it was collected. It is with the bank. But bank did not make any attempt to get an expert report to confirm that the signatures were that of Dr. Shetty. In fact, the burden of proof is on the bank, and the bank ought to have done that. Whereas once something is denied, it's negative cannot be proven, and there is no burden of proof on the person who's denying something. Still, the defendant here undertook the responsibility, submitted an application before the court, requested for appointment of an expert, and an expert report is produced. The bank has not taken any steps up to that. It is in page number 1532.
Sorry, it's what page?
1532.
1532.
Paragraphs 25 and 26. Skeleton arguments, Your Lordship.
Yes, I have that.
Paragraph 25, the witness statements of Mr. Rajkumar and Mr. Sumitra do not provide solid and reliable evidence to definitively establish Mr. Shetty's involvement. Page number 1532, Your Lordship.
Yes, it just so it says this photo alone does not prove that Mr. Shetty signed the disputed UAE facility agreement and the personal guarantee during the meeting. Oh, then he says, Mr. Shetty asserts that the photo was taken during a courtesy meeting. So that's in your skeleton argument, but where are the facts on which you told me that there was no facts stated in your skeleton argument other than what's set out in the particulars of claim?
Your Lordship, that was written in my witness statement, Your Lordship. The witness statement, I did not bring any extraneous information which are not already produced before the court or pleaded before the court, was my submission, Your Lordship.
So the skeleton argument, the skeleton argument doesn't present evidence, does it? It just draws attention.
We are referring to paragraph 41 of reply to UAE expert.
So it's just your statement in your skeleton, is it? It's not anywhere else.
There is a reference to paragraph 41 of reply to UAE exchange response attached as F9.
I'm sorry, say that again, I couldn't hear you.
There is a reference, Your Lordship, in paragraph 26, within brackets in bold letters, paragraph 41 of reply to UAE exchange response attached at F908.
So start with which, sorry, you're telling me the page, were you?
In page number 1532, there is a reference to paragraph 41. Can you take that, please?
Yes.
1532, yes, I have that. That's your skeleton.
Yes, in the skeleton in 26, paragraph number 26.
Paragraph number 26. That's where you say Mr. Shetty asserts that the photo was taken during courtesy meeting. Well, I see it's paragraph 41 of the reply to UAEX response.
Yes,
attached So where do I find that document, the reply to the OEE expert?
I will show it here, Your Lordship. I'll take it.
Okay.
See the paragraph 29 of the claimant skeleton arguments, Your Lordship, about, I'm looking for the other one, the F90, I'll bring it very soon. Paragraph 29 is about the timing of producing the expert's report.
Yes, but I'm looking for where Mr. Shetty says that the meeting was, the photo was taken an express money remittance meeting.
I'm checking that one. I'll bring it to Your Lordship very soon,
Right.
but I didn't want to waste time. I thought I'll fill the gap with another.
Oh, I see. All right.
So my colleague is looking for it. I'll bring it very soon, Your Lordship. So instead of
Right.
waiting for it, I thought I'll take Your Lordship to paragraph
Right.
27 of the skeleton argument of the claimant,
All
where
right.
they stated that about 10th November 2023 and the difference with my witness statement of 25 September 2023,
Right.
why there is a gap, okay?
All right.
The court provided us with permission to conduct an expert, to appoint an expert and to conduct an expert examination of the document and submit a report as per the RDC. We had to submit a separate application to adduce the expert report as evidence, which we have done. Now, the consolidation of the hearing was happening and which we had objected to. Therefore, there was no requirement to submit the report until the timelines were fixed. Timelines were not fixed at that time. It was an application to consolidate the two cases which was being made, whereas our application to appoint an expert in the UAE exchange cases was pending before the court. The application to appoint an expert in the NMC case was allowed. Expert examination was conducted, report was read. So when the registry ordered the consolidation of the hearings, we submitted the expert report in a timely manner. That's all I can say about that, because there was a lag in between.
Well, I have the expert report. I'm not really concerned with
the timing. That's
timing.
Exactly the point, Your Lordship. The bank is also relying on it and referring to it on various places. So I don't think the timing is of such a serious consequences.
And Ms. O'Sullivan didn't make anything out of it. She said in the end that whatever had happened, she doesn't object to me looking at it.
And about Article 1061, they have raised contention, but I have already examined the facility agreement and proven before Your Lordship that it is an all monies guarantee referring to finance documents, any amendments, anything in the future, whatever the liability, this is the language. This is exactly what was decided in Velocity case. Unfortunately, I was the counsel appearing for Velocity's personal guarantors in that case. So I know exactly what transpired there. And the judgments produced, Appeal 261 of 2001.
Sorry, what are you referring to now? The
paragraph number 38 in the claimant's skeleton arguments.
All right. Yes.
See, this particular judgment 261 of 2001 the debt, though it was a continuing guarantee, the amount was quantifiable at the time of giving the guarantee itself, squarely falling within the four corners of the facility agreement itself. Here, I have explained before Your Lordship how the definition of finance document, how the definition of indebtedness, everything goes in this facility agreement. Why the Velocity case is more applicable to this one, not this particular one. And here also the cited dictum, it is established by legal precedents of this court that the guarantee of future debt is invalid except where the value of the guaranteed debt is defined in advance in the deed of guarantee. So it is referring to the finance agreement, and the finance agreement is referring to finance documents, and it's an all-encompassing, all monies guarantee in effect as clearly defined in the facility agreement itself. So this particular appeal 261 of 2001 will not apply. And then coming to paragraph 41, appeal 79 of 2008, Your Lordship. There are 2 points which I believe are in my favor. I mean, in favor of the arguments that I'm raising here. First one is that the opening sentence itself, a guarantee is not valid except if its parties identify precisely the value of the guaranteed debt in the guaranteed agreement, or if the guarantee agreement contains the basis upon which the guaranteed debt may be calculated at a later date, or identifies the nature of the facilities being granted. By referring to the facility agreement and the facility agreement referring to the finance documents, that's not the case in the instant matter, Your Lordship. It's completely open. Now, coming to the seventh line of this dictum, which is cited here in italics. It says, which cannot be ascertained precisely until such time as the account is closed and accounts in respect thereof drawn up. So that's why I said the second point also supports the argument which I'm raising. Article 390. Until such time the current account is closed, the liability cannot be determined. That's why the bank's claim is premature. Maybe we are good for a reverse immediate judgment there, which has happened in many of the mainland courts here. And the current account is not closed and the cases are dismissed as premature. Many cases happen. This is answering your Lordship's question. Here it is. Where I have cited it is actually in my witness statement, which is page number 908, paragraph 41, about this.
Sorry, just let me get there. What page is it? 9?
Page number 908, paragraph 41, Your Lordship.
So that's there. You're stating something which is not in the defence.
Because that witness statements came after the statement of defence. That was the only opportunity. And it is reiterated in the arguments.
That is contrary to the practice direction, isn't it?
Yes, Your Lordship, to a certain extent, but it's not a controversial thing that I'm stating, because that is a photograph, and it's just the photograph was presented to...
Well, it's a very controversial matter when the photograph was taken.
A photograph is explaining the context only. The photograph is not denied. The photograph is there. It's only...
No, but the critical point is when the photograph was taken. Was it taken on signing the facility agreement of the personal guarantee, or was it taken on this event to do with the money exchange? That's a critical fact.
Very critical, Your Lordship, can only be brought up if I cross-examine the witness. Then
no, Mr. Shetty could have given evidence about it. He could have signed a witness statement saying that's when it occurred.
True, I must admit it was a possibility.
But he hasn't. And shouldn't I attach some significance to the fact that he's not been willing to sign a witness statement saying any of this?
I don't want to raise any arguments on that, Your Lordship, and the witness statement was submitted by me, and that was the opportunity. So when it came to that particular area, it was mentioned that this is how it happened, as explained to me. That's all I could do at the same time. Sorry for that. And then
Whilst I'm on that subject, there is no explanation. It's not said anywhere, is it, that Mr. Shetty could not have signed a witness statement? There's no reason why he could not have signed a witness statement, is there?
1 second, Your Lordship. Let me just check with my. I'll verify that why he's not in the country. He's out of station is one point.
Is there any evidence before me that he could not have signed a witness statement?
I'll find out and come back to you.
And similarly with Binay, is there any evidence before me that he could not have signed a witness statement?
Only thing I would assume here is due to the time constraints that all of a sudden a consolidation of the cases was happening, immediate judgment application was coming. So in that context, it was probably not an easy thing to coordinate between them staying in different countries and to get them to discuss all the things and get a witness statement from them.
So that is something that you are offering from the bar table. There is no evidence before me,
yes, Your
in
Lordship,
any form that either Mr.
and these are
or Mr. Binay could not have signed a witness statement. Is that right?
these are all matters for the trial, I would say, Your Lordship, not for
No, I'm talking about whether he could have signed a witness statement for this hearing. There's no evidence before me that he could not have signed a witness statement for this hearing, is there?
Yes, Your Lordship is absolutely right. We have not produced anything. Even I'm myself not aware why that was not possible. I'm only trying to assume as the moment that because of that.
Well, we could all assume things. There's no point in that has no evidential value.
Yes, one second, Your Lordship. I'll just take instructions. Again, no evidence, Your Lordship. We had contacted and it was stated because of Dr. Shetty's then medical conditions, he was not in a position to give a witness statement.
Sorry, where is that? Where does it say that?
No evidence. We in internal communication.
I only want to deal with what the evidence is.
I understand. I started by the opening word, again, no evidence.
Right.
Your Lordship asked me a question.
All right.
Took instruction.
Thank you.
So I could only place it before Your Lordship that an opportunity should be given and it requires a trial, not an immediate judgment. I will again use it to support my argument why a trial is required in this case.
All right.
Then examination is required. Maybe contra evidence is required. We may also have witnesses to show what exactly was happening on that date, why that photographer, who else is seen in the photograph. We may cite them as witnesses also.
Well, again, you could have brought, so you're saying that you might give evidence from the people who are in the photograph. But you could have done that now. You could have done that now, could you not?
Not now, Your Lordship, because now the company itself does not exist. The people are not around. We have to find them. It requires time. Even to contact one person, I know how difficult it was for me to get something.
All right.
It's not like a company regularly functioning. People are coming to the office every day. I could have done it on the same day, Your Lordship, but that was not the case. And the amount involved is so high and the people are of that profile.
Yes, all right.
To get in touch with them and they have to do some investigations to find the people even. They would have gone to different countries. So I must conclude my submissions here, Your Lordship. My humble submission is that there's every possibility for a successful defense in this particular case. And this is not a case fit for immediate judgment. If at all there is an immediate judgment, it can be a reverse immediate judgment because of the findings of the expert and the way that NMC guarantee is executed which shows no trace of acceptance or consent in the first 6 pages. And last page is only this guarantee is executed. And the allegations are of very serious nature. The application for examination of the guarantees given in the UA exchange case is pending before the Honorable Court, so it requires a trial. The witness statements have been produced very lately by the other side. It requires cross-examination, counter witness statements, finding the parties, bringing more evidence to the table. This is the way a trial should be conducted. And the number of legal provisions that we have quoted here from the applicable UAE law, at least in one case. When there is a combined trial, I believe it has an impact on both the cases, and UAE law is applicable in the larger case, which says that Article 390 current account has to be closed, no evidence that the current account is being closed, and if the evidence is to the contrary when interest is being calculated on a daily basis, and if an illegality is committed, that has to be removed and can only happen by appointment of a banking expert well versed with calculating interest according to the guidelines given by the mainland Supreme Court, in order to completely eliminate compound interest from it. When the matter is stayed before there are case filed against several parties, and the main party is the case is stayed. So it's only a natural consequence. Nobody need to be in a hurry here. We can wait until a proper trial is conducted against the borrower. The amount due from the borrower is determined. Who knows, maybe the borrower will come and admit everything. And then you don't need a trial at all, because that arguments, everything is gone. Once the borrower admits, it's proven that there is a liability and the guarantor's liability kicks in. But what if the borrower comes in? He is raising same arguments like Article 390, 1061, 121, all this, then there has to be a trial. So we cannot assume that the borrower, just because there is a stay order, matters are all stayed all over the world. Just because of that, there is no proper defense for the borrower. It's not a possible assumption. It's a serious amount. There is a serious trial required in the interest of justice. It's all in the interest of fairness and equitable administration of justice that both parties should be sufficiently heard. The principle of natural justice warrants that. So with all this, Your Lordship, and the findings of the expert again, although it is all, we could have found it by ourselves also, it's so glaring, so apparent, so obvious to naked eyes. It's all the more important we have to take it into serious consideration. This is not the way a bank is supposed to function. And this way, you can attribute any papers to anybody's signature. If signature is obtained on one page, even if that was the facility of 150 million, there's nothing which would have stopped the bank.
With respect, Mr. Shaheen, I think you're getting a bit repetitive on that line, aren't you?
Yes, Your Lordship, because that's the main contention regarding the guarantee given. And the allegation is from the personal guarantor is that it's not that this particular person forged it. He doesn't know. He only said, I don't remember, I have not signed. It could be the management, it could be the bank, it could be a wrongdoing done by both of them in collusion. This is the possibility. Which possibility
or it could be him, because he says he can't remember, he doesn't know. Could be him as far as he's concerned, it could be him.
Yes, very much possible, Your Lordship. The last page were his signature, this could be him, but the other 6 pages cannot be attributed to him. That's very clear again. And there is nothing, no binding proof, no evidence to show that he had accepted the first 6 pages. Nothing to the contrary, where the denial is there, burden of proof is on the person who asserts it. So my humble submission is the application for immediate judgment is liable to be dismissed with cost to the defendants, Your Lordship.
All right, let me just check before you finish. You told me that there was evidence refuting Mr. Srinivasan's evidence that he witnessed that he saw Mr. Shetty sign the document we've been looking at and that he witnessed it. Is the evidence, and you told me there was evidence refuting it, by that do you mean the evidence of the expert? Is that what you're referring to?
We pointed out that, Your Lordship. Where is the paper? Is this one? One second, Your Lordship, I'll just find out. I remember explaining that, but Lordship is asking for a reference, I have to find it. I parked it for a moment and then came back to clarify that I remember, but which exactly the reference is what I'm looking into. It was in the beginning of the statement of defense. I think it was clause 3 or something. Yes, the misuse of this is page number?
Page
524, Your Lordship.
Sorry, what page?
Page number 524.
524. Now this is
Roman letter 2.
This is your witness statement.
This is what this is statement.
This is witness.
Witness statement, yes.
Yes,
This
and
is,
which paragraph am I to go to?
Roman letter 2, misuse of Mr. Shetty's signature. Paragraph that is referring to paragraph number 4 and 13 of Mr. Shetty's statement of defense.
Sorry, so I go to the section which is Romans 2, misuse of Mr. Shetty's signature.
Yes, Your Lordship.
And then there are 5 paragraphs under there. Is that the paragraphs, as you're saying, that's the refutation of Mr. Srinivasan's evidence, is it?
This is also referring to paragraphs 4 and 13 of Mr. Shetty's statement of defense also, by which it is concluded that Mr. Shetty had no knowledge of the arrangement that purportedly gave rise to execution of the disputed
Right.
and Mr. Shetty also contended that he did not authorize any person to. That goes further down.
All right. All right, thank you. Well, thank you very much, Mr. Shaheen. And now, Ms. O'Sullivan in reply.
I have a few minutes. Would your lordship like me to go straight ahead, or would you like to rise for a short time?
When you say a few minutes, so is that sort of less than 15 or?
Yes, it's between 5 and 10, I'd say.
Well, let's go.
Okay, fine, thank you. Well, I'll cycle back to where I started, Your Honour. This is the clearest possible case for immediate judgment. It's beyond hopeless on the legal points, and the defences of fact are dishonest. Now, whose dishonesty? Now, in relation to NMC, the pleaded defence is that Mr. Shetty has no recollection of signing the facility documents. Well, an honest witness, faced with the evidence of Mr. Srinivasan, would have said, oh yes, now I remember, and then would have gone on to take any other defences that might be available to him. But instead, through his counsel, he has doubled down, and counsel is now advancing a totally unpleaded argument that the bank somehow doubled up, took a signature from another document, God knows what other document, and stuck it behind not the personal guarantee or the facility agreement, but 2 other documents signed by Dr. Shetty on the 7th of August. So none of this is supported by a pleading or witness statement from Mr. Shetty himself, but one has to assume that Mr. Shaheen is acting on the instructions and with the authority of his client in advancing this case. Now, in relation to UAE exchange, Mr. Shaheen has said that there's an application for inspection of the documents. I have taken instructions. That's not right. No request has been made to inspect the documents. No application has been issued. So what Mr. Shaheen told you, Your Honour, was untrue. Obviously, if a request had been made, the bank would have permitted inspection in the same way it has permitted inspection of the NMC documents. What is particularly intriguing, Your Honour, is that Mr. Albar was not provided by his own client with samples of signatures for comparison. It was, as I've said from the outset, it was impossible for Mr. Albar to form any view on the authenticity of the signatures because he wasn't given the basic material he needed for that purpose. Why wasn't he, I ask? Is it because Dr. Shetty was concerned that the expert evidence wouldn't support his case? I submit that it was. I mean, I'm afraid this defence is very much the default defence in the DIFC court where claims are brought on personal guarantees. The standard defence is, I didn't sign it, I want to get an expert to examine the signatures. Well, that's actually happened in the NMC case, and even with inspection, they couldn't come up with anything credible. I mean, as I say, Mr. Albar has completely and improperly stepped outside the remit of an expert in offering completely unevidenced assertions of dishonest and dishonourable conduct on the part of the bank. However, you don't have to go as far as finding that the defence is dishonest. You simply have to find that there's no real prospect of successfully defending the claim. And in my submission, that is comfortably met by the evidence which you have seen. It might be worth looking at the Al-Mazrari case, because my learned friend says, well, anything is possible. Anything is possible is not a defence. What can I do is not a defence. So if one looks at page 1511, which is my skeleton.
Oh, okay.
That's where I set out at paragraph 16, the quote from the Chief Justice.
16?
Paragraph 16 on page 1511.
Yes, I've got a hard copy of it.
Yes, paragraph 16.
Yes.
Now, on burden of proof, and obviously the burden of proof rests on the bank, but I mean, there is at least an evidential burden on the respondent. If he's going to allege forgery, he has to produce something on which the court can act. And that's essentially what the Chief Justice is saying here. He must produce something, some ground, basis or fact that can enable the court to conclude that there is a sufficient basis to claim that forgery had taken place. And then he goes on to the handwriting expert. Well, we've got a handwriting expert, but because he wasn't given the material he needed, he was unable to reach any conclusion on the authenticity of the signatures, and is said to have to come up with this nonsense, this improper nonsense about, oh, well, the bank must have copied it over from some other document. Now, yep. So that's really all I have to say about the defence, the so-called defence of forgery, if it goes that far. So I think I'm going to be quicker than I thought. In relation to the legal arguments,
yes.
Mr. Shaheen made some arguments about the construction of the facility agreement, but of course he didn't answer my point on clause 6b of the NMC guarantee at all, which is an express waiver of any defences arising under UAE law. And I think I heard him concede that the Article 1061 doesn't apply to the UAE exchange guarantee because that's governed by DIFC law, and as we know, UAE commercial laws don't apply in the DIFC. So that takes care of the point. So you don't really need to get into the construction, but my learned friend was taking you to the construction of the facility agreement. That's not the right document. What you have to do is construe the guarantee and see whether it falls within the four corners of the facility agreement, which is the approach that Justice Glennie took. Now, obviously, on the drafting of this personal guarantee, it clearly does fall within the four corners of the facility agreement in the way that it did not in the Velocity Industries case. So that's that point. In relation to interest, it might be useful to look at what Mr. Kumar says at page 625 of the bundle, and explains paragraph 22. This is in relation to the UAE exchange account, but the same is true of both of them. So the loan facility account was classified as a non-performing account on the 1st of June. And then, so as at that date, the account was transferred to a category classified as 76115. That is in effect the closure of the account. And that's why the interest calculation that you've seen at 1915 and 1916 begins on the 1st of June 2020, because the balance that was carried over at that date includes accrued interest until the 1st of June. And then interest is then calculated on that going forward. Yes, that's a good one. Yes, I mean, just to remind you, the statement of account for NMC is at page 197. We looked at that briefly, and you can see it's basically it's a list of all the entries on the account, concluding with the final entry, which is on the 1st of June, where it's transferred to non-performing asset. And you find the same information in relation to UA Exchange. The final page is 788 for your honour's reference. Gets transferred over to 76115. So if your honour wishes to see a witness statement verifying the basis on which interest has been calculated,
Yes.
that could be done. I would ask for the indulgence of 7 days if that's of assistance.
Well,
but sorry.
Then the claimant may file and serve within 7 days a witness statement or statements stating and proving the amount payable by the second and third defendants in 43 of 2021 and the 6th defendant in 90 of 2020.
Thank you very much. And then if there are any points out of that, I assume that one could address them in writing. I'm afraid one must expect every point, no matter how bad, to be taken on behalf of the defendants in this case, as you've heard. My final observation is in relation to the Barclays Bank and Shetty decision of Justice Martin. You asked my learned friend to comment on that, and he said he was going to, but he hasn't. And the reason is he doesn't have an answer. But subject to that and any questions your lordship may have, I think I have addressed in advance the points made by my learned friend in my opening submissions and in my skeleton, to which I refer you.
Yes.
And I would say this is a miserable, broken back defence, and you ought to put it out of its misery and administer the coup de grace.
Thank you, Ms. O'Sullivan. Mr. Shaheen, you said to me that the Mr. Shetty had made an application to inspect the documents in the UAE exchange matter,
Yes,
but it hadn't been dealt with. Ms. O'Sullivan said there isn't such an application. Is there an application?
That was during the case management conference, Your Lordship.
No, there hasn't been one.
So let's deal with a bit at a time. No application has been filed. Is that correct?
Not a formal application, but it was during the discussion about whether there will be a case management conference that we had to submit that.
So there was a case management conference, was there?
No, it did not happen. That is why
No.
it was the formal one was not submitted.
Right. So there's been no case management conference. There's been no separate application. So there is nothing you can put. Is there anything you can point to in the evidence that you made an application?
We mentioned it in our submissions to the Honourable Court that it is required.
No. Is there, in the evidence before the court,
Yes,
any evidence of an application having been made?
no, a formal application has not been made, but it was
All
required.
right. Well, I wanted to correct that.
Yes, Your Lordship. And
All right.
2 points, if I may be allowed to clarify from what Madam submitted just now. One is about the specimen signature.
All right. It's irregular, but all right.
Sorry, Your Lordship. It's about the specimen signature, page number 1370.
I'm sorry, what?
Page number 1370.
And Ms. O'Sullivan, I'm going to give you a right of reply if it's necessary.
Let's see if I need one.
1370. Yes, I have that.
The letter of undertaking given by the attorneys of the claimant, which confirms that we have submitted the specimen signature of Dr. Shetty.
Let me just have a look at this.
Dated 13/9/2023.
Have submitted the specimen signature
Of the 6th defendant, which is the Shetty.
Yes.
So we have submitted.
That was given to you for the purpose of the expert carrying out his examination, was it?
Our expert always had it. And he never said he did not receive the specimen signature. I don't know why.
So what's the significance of the letter I'm looking at?
The defendants were never hiding the specimen signature as alleged by the claimant's counsel. It was submitted to the claimant's counsel as early as in September.
Now, what Ms. O'Sullivan said, well, the bit that I took note of, was when your expert went to inspect the personal guarantee, he did not take with him any specimen signatures provided by Mr. Shetty as being genuine signatures of Mr. Shetty. So Ms. O'Sullivan said he didn't go equipped to and able to make a comparison of the signatures because you, Mr. Shetty, didn't give him a specimen of his genuine signature. That was the point that I understood Ms. O'Sullivan to make.
He always had the specimen signature with him, is my understanding.
I'm sorry?
Always had the specimen signature with him. It was given to him at the time of engaging.
It was given to him by Mr. Shetty or by you, was it? Not referred to in his report, is it? Or is it?
He did not go for that signature examination saying that it's only on the last page. There's nothing on the last page. This is what he stated.
I'm sorry, could you just say that again?
It was only on the last page the signature was there, and there was nothing on the last page. Other pages are not signed. So even if the signature is proven to be of him, it doesn't apply to the other pages, is what his finding was.
Well, the point so Sullivan made was, and I think you're confirming it, he did not go to compare the signature on the document with Mr. Shetty's genuine signature. He did not attempt to do that. And I think you're agreeing with that, are you?
I'm agreeing to the fact that he did not compare the signature of Dr. Shetty with the specimen signature. But yeah, I don't know whether he went for that or not. I don't know. His conclusion is that it doesn't add any value in the given context, is what he wrote in the report. So did not compare his fact.
No.
Now, just to clarify something in the guarantee, the waiver clause which my learned friend referred to, that is clause 4.2 in the NMC guarantee.
Wait, what page is this?
Page number 76 is the first page number. I'm looking at the page number 3.
78.
76 or 76, 78. 78 should be 78, Your Lordship.
So this is the guarantee.
Guarantee, and the waiver clause was referred to by my learned friend.
Yes, she did in her principal submissions, and she raised it again in her reply.
Yes, Your Lordship. If
she referred to paragraph 6, subparagraph B.
4.1 and 4.2. So here it only further enhances my case that this is an all monies guarantee. 4.2 under the waiver clause. Until all the covenants, terms, and agreements, all the facilities shall have been completely discharged to the entire satisfaction of the bank. The obligation of the guarantor shall not be modified or impaired upon the happening of from time to time any event including but not limited to, and a long list of things. It concludes that it's an all monies guarantee.
The principal point Ms. O'Sullivan made was paragraph 6, subparagraph B. The guarantor further waives all rights, remedies, defences or exceptions which are or may be given to the guarantor under the laws of the UAE.
Yes, Your Lord.
You said you were going to respond to that, but you didn't.
Yes, that's exactly what I'm coming to. First, I wanted to touch upon that. Then the continuing guarantee clause also enhances my case. And it's not for the parties to waive the application of law. When the application of law is clearly specified, you cannot waive one or two clauses of the law, say that this law doesn't apply to me. The law is applicable.
Let me understand your submission. You're saying as a matter of law that the guarantor cannot waive.
Yes, Your Lord. That's exactly my submission.
That's your submission, is it? Do you have any authority for that?
And yes, we can produce documents, because the other arguments, like anything which the bank has typed in a form of letter of guarantee and the parties have signed, if it is contradicting the law, the contract, the object of the contract has to be lawful. The contract has to comply with the law. Contract has to be within the frame of
Yes.
law.
Do you have any authority for that proposition, or are you just asserting it as a matter of principle?
I'm saying it's as a matter of principle, but if I get an authority, Your Honor.
So your submission is that as a matter of law, a guarantor cannot waive their rights, remedies, defences or exceptions under the UAE law, or if they purport to do so, it's not effective. Is that your submission?
By that, Your Lordship, we can say applicable law is UAE law, and all those protections given to the guarantor are waived. If that is the extent the allowance given to a bank, which is impossible. Once the applicable law is there are certain protections given to the parties, especially in a banker-customer relationship. The bank is supposed to be the expert, caring for the interest of the customer also. There cannot be blanket clauses waiving all the protections given under the law.
All right, that's your submission.
Yes, Your Lordship.
All right, does that conclude your rejoinder?
Yes, Your Lordship. Thank you.
All right, I'm going to give Ms. O'Sullivan an opportunity to respond if she wants to that last submission.
Yes, I mean, there might be some force in that if this were a consumer guarantee, I suppose. But I mean, this is a commercial guarantee. This man is said to be worth $1.93 billion US. He's a highly sophisticated businessman. He's founded two massively successful, at least apparently successful groups. And I can't see for any reason why the party should not contractually agree that certain defences should not be available. It's completely standard. And there's a similar point in relation to paragraph 4.2, which we were just looking at. And I've described this as boilerplate wording because it's intended to circumvent the application of the rule in Hall and Brumskill. And I mean, anyone who's done any work with bank guarantees will recognize this sort of language as entirely boilerplate. It will appear in every guarantee, and there's nothing at all objectionable about that. I mean, you know, these are parties advised by lawyers who are perfectly capable of negotiating, and that's what's happened here. These points are as hopeless as all the rest.
All right, well, thank you, Mr. O'Sullivan. Thank you, Mr. Shaheen. I thank you both for your assistance and those assisting you. I will reserve my decision.
Thank you very much, Your Honour.